So I wish to welcome you to this afternoon session. My name is Anna Petrik. I'm a professor of international law at the University of Basel in Switzerland, and I have the honor to moderate this hybrid panel, which is entitled Jurisdiction in Human Rights Law. Before introducing the panel, let me express a word of thanks. I guess if one thing became clear this morning, it is that there is no single uniform framework in order to identify which state has jurisdiction over persons at sea. Rather, we need to draw on at least three frameworks: general international law, law of the sea, and international human rights law. And we have to understand how they interact. However, these bodies of law are usually analyzed by lawyers belonging to different guilds, and guilds tend not to speak to each other too much. So I would really like to thank Professor Papanikolapoulou for bringing together lawyers from different guilds to discuss this challenging subject. This panel turns on jurisdiction in human rights law, and we have heard this morning that jurisdiction is key for identifying which state or which states are under an obligation to respect, protect, or fulfill human rights. We have this term jurisdiction in the International Covenant on Civil and Political Rights. We find it in the first provision of the American Convention on Human Rights and also in the first provision of the European Convention on Human Rights. All these treaty provisions make the application of rights and freedoms contained in the respective instrument contingent on the state exercising jurisdiction over the person. The concept of jurisdiction as used in human rights law is still under construction, under development. However, decisions from judicial and quasi-judicial bodies provide evidence that the notion of jurisdiction is a composite notion. On the one hand, it refers to de jure jurisdiction, the power conferred upon a state by a legal rule to either legislate, enforce, or adjudicate. However, the notion of jurisdiction has also, in addition, an autonomous and human rights specific component, which is usually referred to as de facto jurisdiction. And this includes all those situations in which a state acts using its power, and it's independent whether it's permitted by a rule of international law or not. And it is especially relevant in the context of extraterritorial facts. So the question then is, what kind of normative relationship between the individual and the state is necessary in order to trigger this de facto jurisdiction? And here we have already seen it this morning, the notion of control is of essence. The problem is that both de jure jurisdiction and de facto jurisdiction under international human rights law have been mainly discussed and considered from a dry land perspective. And Professor Papanikolapoulou has mentioned this morning that this territorial vision or perspective is not a sensible one for the seas and oceans, which are in its largest part not comparable to territory. So the question is then, how could the notion of jurisdiction under human rights law be understood in the context of protection of people at sea specifically? What normative relationship between the individual and the state triggers human rights obligations of the latter vis-à-vis the former? So we have four persons here who are uniquely qualified to contribute answers to this question and to provide us with food for thought. Three of them are here in the room. One person is online, and they all have very impressive CVs. So I was wondering which items from these CVs to pick to present them, and I didn't want to do that arbitrarily, but I applied the criteria, so why not taking jurisdiction, which has this allocative function, and I will just mention what they did in terms of jurisdiction and human rights law. So we first have on the panel Professor Marko Milanovic from the University of Reading in the UK, and he was one of the very early adopters of the concept of jurisdiction under international human rights law. He was among the first publishing a monograph in 2011 called Extraterritorial Application of Human Rights Treaties, Law, Principles, and Policies. So you were among the first to develop this notion from a land perspective. Then we have online Professor Violeta Morena Lax. She is based at the New York University and Queen Mary University of London. She's currently in New York and will therefore present online. She has also extensively worked on jurisdiction, and she has coined this expression of functional jurisdiction. She has notably published in the German Law Journal a piece called The Architecture of Functional Jurisdiction, and she has done so in the context of a specific case, SS and others versus Italy. We have already heard about this case this morning, and I'm mentioning this case because Violeta Moreno Lax was very active in bringing this case before the European Court of Human Rights, and it's one piece in strategic litigation in the area of border violence and migration, where this concept of extraterritorial jurisdiction becomes very relevant. Then we have on my right side hand Dr. Lea Reible from the University of Glasgow, and she has also published an entire monograph on human rights and extraterritoriality. It's called Human Rights Unbound, a Theory of Extraterritoriality, published by OUP in 2020, where she explores the concept not only from a legal perspective, but also from a political, philosophical perspective. Last but not least, we have Dr. Christoph Gombert for Leiden University, and he has also done extensive research on the extraterritorial application of human rights, specifically at sea and in the context of migration. He has written an excellent PhD on the relations of duty in the age of rights, a study of the supply side of human rights in the context of maritime migration. So now, without further ado, I would like to give the floor to Professor Marko Milanovic. Each of the panelists has 20 minutes for presentation. We will take questions only after the four presentation, because as we will see, we will hear different theories on what could be the normative relationship between the individual and the state which triggers human rights obligations. So it will be very nice to have one big discussion at the end. So the floor is yours. Thank you.
Thank you so much, Anna. Thank you to Irene in particular for inviting me, and thank you all here for having me. It's a pleasure to be here. So the title of my talk in the program is that I would talk about one easy and one hard scenario of extraterritorial jurisdiction on the sea, and I realized basically that I lied twice when I did this this title, because I won't talk just about two scenarios. I'll talk about many scenarios, but really in two groups. And as you will see, my main argument, and maybe I'm being a bit deliberately provocative, is that there's nothing special about jurisdiction on the sea. And that we need to, in this human rights context, if we're applying human rights law, we need to apply principles consistently that apply to various scenarios to the extent that they're sufficiently similar, and that the difference between the land and the sea is not necessarily so important. So I will develop this thesis basically as we go on. So I'm being deliberately provocative and a liar. So let me then explain sort of this core argument. So there's one conceptual point that needs to be clarified first. And by the way, apologies, both Leah and I missed the first panel because we were on a flight from London. And so if I say something that has already been said, mea culpa. I'm so sorry, it couldn't be avoided. The first thing that really needs to be clarified is that the notion of jurisdiction in human rights treaties uses the same word, but has a very different meaning from the notion of jurisdiction in general international law, including in the law of the sea. The notion of jurisdiction in general international law or the law of the sea is when can the state create or apply its own law. It's about the state's domestic law and the creation and enforcement of that law. So for example, if Serbia issued a surveillance warrant for somebody in Milan, and if the Serbian police hacked my phone in Milan, we would say Serbia was applying its laws on criminal procedure extraterritorially, and it was enforcing them extraterritorially without Italy's permission, something that's normally a violation of Italian sovereignty. The notion of jurisdiction in human rights treaties is very different. It plays a completely different role. It's not about the delimitation of legal systems of states. It's not about whether states infringe on each other's sovereignty when they apply or enforce their domestic law. It's about whether states owe duties to individuals. The first time anyone ever thought that these two concepts are the same is in the most awful decision of the European Court ever delivered, this Bankovic versus Belgium decision. Nobody before that ever thought the same. Yeah? And this was a case in which the court ruled that if states bomb people from the air, the right to life does not apply. Do you understand? So that bit of confusion that these are the same, that this, even though it's the same word, that these are the same concepts, should be avoided. These are very different concepts. And if you look at the case law on human rights jurisdiction, it has revolved around two mainstream models and some new ideas. So let me just very briefly say what the mainstream models are. And again, I'm sorry if I'm repeating stuff that was already said, and then I'll move to my core argument. The two mainstream models have been, first, that if a state controls the territory of another state, lawfully or unlawfully, it has to respect and protect the human rights of people who live there. i.e., if Russia occupies Crimea or eastern Ukraine, it has to comply with human rights obligations towards all the people in those areas, regardless of whether it's there lawfully or unlawfully. If Israel controls the occupied Palestinian territories, it has to respect, protect the rights of Palestinians, regardless of whether it's there lawfully or unlawfully. Yeah? That's the first approach. The second approach, the actually much more complicated approach, is that if a state controls the victim, so it exercises authority, power, control over the victim through its agents, the state will have obligations. So the classical example here is this case called Lopez Burgos versus Uruguay before the Human Rights Committee, where Uruguayan secret agents go onto the territory of Argentina, they abduct a guy, and the committee says, from the moment you hold that person, you have to respect their human rights. And the issue has been, in the case law, how far exactly does that principle extend? So that brings me to my core argument, right? That there's nothing special about the sea. Yeah. So that really revolves around two propositions. The first is this: there is no formal good legal reason why the applicability of human rights treaties should depend on external bodies of law that are not human rights treaties. Yeah? There is nothing in the text of human rights treaties or in the text of these other treaties that in any way suggests that the applicability of human rights treaties should depend on some other piece of law that was drafted by completely different sets of people at completely different sets of time with completely different purposes. Yeah? If you want a textual hook, you don't have it. There's nothing in the text that suggests, for example, that the application of human rights depends on the law of the sea or on the law of armed conflict or on, I don't know, international environmental law or whatever other part of international law. Yes, we do have the principle in the Vienna Convention, the law of treaties, Article 31(3)(c), that we should, take into account other obligations between states in interpreting treaties. That's fine. But that goes to the merits question of substantive question of how do they apply together at the same time. It does not, in my view, relate to whether human rights law applies at all. So to give you the example that has been the most controversial in practice, we now have situations of applying, say, the European Convention on Human Rights in armed conflict. Yeah? Currently, there's a case pending before the European Court, the Ukraine and Netherlands versus Russia, which is about the downing of the MH17 airplane. It's about hostilities in Ukraine in 2014 and about hostilities in Ukraine in 2022. All of this stuff takes place while the law of armed conflict also applies. That does not in any way entail that human rights do not apply. All that means is they apply at the same time, and that some specific rights, like the right to life, should be interpreted taking into account the relevant principles of IHL. So formally, there is no good reason why human rights law, the applicability of human rights law should depend on anything other than human rights law. And then normatively, I really think that the proposition that the sea is somehow special is dubious. Because everything then is special. Cyber is special. Armed conflict is special. Climate change is special. Transboundary environmental harm, everything becomes special. So what we need to have are principles that can be applied with some reasonable degree of consistency so that we do not value the lives and interests of people differently. So that people are valued equally, at least in principle. So that would be my core argument. So how does that now, I want to develop that by looking at some scenarios. Now, what are these two basic groups of scenarios? So in the book that Anna very, very kindly mentioned, I put forward this argument, which I can boil down to the following thesis, that there is a difference, a substantial difference, between situations that engage negative duties under human rights law, so the duty to respect human rights, from those that engage positive duties under human rights law, the duties to protect and fulfill human rights. In the first situation, the state acts in some way that harms individuals. In the second situation, the state fails to act. It might be culpable by reason of omission for failing to do something that it should have done. And my core argument in the book is that these are really fundamentally different situations, and that in principle, all situations in which a state acts to harm an individual should, in my view, be covered by human rights law. Either because no jurisdictional requirement applies at all. This is actually my primary thesis. That if I kill you, for example, imagine I'm a Serbian state agent and I kill Anna, my argument is that we shouldn't even do a jurisdictional inquiry. The duty to respect applies without boundaries. To the extent you think we should do a jurisdictional inquiry, I would say then the idea of jurisdiction as authority, control, power over the victim boils down to the proposition that whenever I harm Anna, I have her under my authority, power, control. Okay. However, positive obligations are different. And in my book, basically, I argued that probably the most plausible approach would be to limit them to the state's territory or the territory it controls. That does lead to arbitrary results, as I'll acknowledge. So obviously, some people I know are not necessarily happy with this approach. And I'm happy you're not happy, and we can talk about it. But the approach, I think, is grounded not just in, like some legal formalist thing. It is grounded in actually a very fundamental moral point. If you look at moral philosophy, for thousands of years, literally, and if you just consider our basic moral intuitions, we all think there are meaningful moral distinctions between doing harm to another person and failing to stop harm to that person. So for example, if I go now and drown Irini in a pond, that is obviously morally worse than me seeing that Irini is drowning and failing to come to her rescue. Yeah, there's an obvious moral difference between the two scenarios. Hey, yeah. I hope I make sense. I'm not going to do it. You're going to feed me for dinner. So this brings me to my two first scenarios. So my first scenario is negative duties. And here, I think basically this. Those among us who really care about human rights at sea need to come up with solutions that work in other contexts as well. You cannot have an argument that only works at sea. And I think we need to start from the very simple scenario. The simplest scenario is actually killing. Well, let's just do that. A state sends an assassin onto a territory of another state. There is no normative relationship here. Yeah? It's not like the state extended its domestic law. The state just sent an assassin. Russia, a month ago, sent an assassin to Portugal to kill a former Russian pilot who defected to Ukraine. So the question is, does the right to life apply if Russia assassinates a guy in Portugal, if Russia poisons Alexander Litvinenko in London, if Russia, I'm using Russia, but you can use whatever state you want, poisons in Salisbury using chemical weapons? I don't think we need to think about this issue in terms of, in general international principles of jurisdiction, normative relationships. This is a state killing somebody outside its territory. My main argument is that this kind of scenario has to be covered by human rights law. It took the European Court of Human Rights a while to reach that conclusion. Now it has adopted that conclusion in a case called Carter versus Russia that is precisely about the assassination of Alexander Litvinenko. A step below that, a state uses a cyber operation to harm a person abroad. So imagine Irini is targeted by Serbia using Pegasus. So Serbia hacks her phone while she's in Milan. Serbia is a party to the European Convention of Human Rights. Does the right to privacy apply if Serbia, regardless of its domestic law, there might be nothing in Serbian domestic law about this, Serbia just does this, yeah? Hacks Irini while she's in Milan? I think it does. Either because no jurisdictional requirement applies at all, or because the mere fact of spying on her is an exercise of authority, power, control over her. The same goes for armed conflict scenario. If a state kills somebody with a bomb, or a drone strike, or a missile strike, or an artillery shell, which is now the issue in Ukraine versus Russia, the big case. The same goes for scenario about transboundary environmental harm. So imagine state A emits poison onto the territory of state B, which harms an individual in state B. Should the right to life apply? Yes. Should the right to food apply? Yes. Yeah. Should the right to health apply? Yes. Yeah. So that's, if you see my core argument. Now, how does that work on the sea? It works on the sea. Yeah. By the way, so we now have these climate change cases pending before the European Court of Human Rights, the Inter-American Court of Human Rights. It lost the ICJ. Whatever position we think is valid on the sea has to work for climate change cases as well. So let's work on, work using these examples on the sea. Imagine if a state uses a drone to kill a person on a ship on the high seas. Should human rights treaties apply? Yes. Does it matter whose flag the ship flies? No. Whoever is it a Panamanian ship? Is it a, Australian ship? Is it a Russian ship? No. If America, say, kills somebody using a drone on the high seas, the ICCPR should apply. If they spy on people aboard a ship using a drone, so there's audio, visual observation of the person on the high sea, surely the conventions, all the human rights treaties should apply, regardless of whether domestic law has extended, regardless of flag jurisdiction. If states' agents detain a person on a ship, surely human rights treaties should apply. If they refoul them, if they engage in pushback, Hersi Jama, right? All of these treaties should apply. If a state vessel collides with a vessel of another state, injuring people aboard that ship, SS Lotus, yeah? Obviously the right to life should apply. This is, you see, my view. So The difficult bits in these negative duties are complicity scenarios. Okay, that's really the tricky stuff. So imagine the following situation. State A shares intelligence with State B, knowing that State B will do something bad to a person on its territory. So let me give you a real example. The UK told the Americans that this guy called Belhaj and his wife were Al-Qaeda. And the Americans told that to the Thais. He was in Thailand at the time. And Mr. Belhaj was arrested in Thailand, given to the CIA, put on a plane, taken to Libya, where he was tortured. Yeah? Everything starts with the UK sending a piece of information to the United States. It is contributing to a wrong done by the United States and by Libya. This is a complicity scenario. See what I mean? It's not the UK who tortured the person, but the UK knowingly contributed to that wrong. In my view, again, these negative duties should be unlimited in the complicity scenario. Human rights treaties should apply. We say sell weapons to states, knowing they will use those weapons to commit bad things. Yeah? So, for example, the UK sells weapons to Saudi Arabia that Saudi Arabia uses in Yemen, or we will sell weapons to Israel that it might use in Gaza. Should human rights treaties apply? I think they should apply. This brings us to the high seas, or the seas. State A uses a drone or a satellite, and it sees a migrant boat, yeah, in the Mediterranean. And let's say State A is Italy, and it sends that information to Libya so that Libya could take the vessel. This is sort of the kind of similar to the SS case kind of factual pattern, right? Or State A receives a distress call, but forwards that information to State B, knowing that State B will do bad things to migrants it rescues on the Mediterranean. So these are complicity scenarios. Again, to my mind, they should all be covered by human rights law. But my point is simply this: you cannot have a theory under which on the seas these kinds of situations are covered, but on land they are not. Yeah? You cannot have an argument that says, well, this kind of relationship of complicity is only wrongful if some weird principle of the law of the sea is engaged. No, 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 no. Yeah? Either all of complicity works in the way I described it, or none of it works at all. So that's the tricky bit in the negative obligations subgroup. The really difficult cases, though, are about positive obligations. Yeah. Now, why are they really difficult? For a couple of different reasons. One is that, and I think Leah has written about this and may talk about this. One is that these positive obligation scenarios often require distribution of scarce resources, often require the sharing of burdens. And human rights law is not really well suited to make these kinds of distinctions. Yeah? The other is because, again, as a matter of moral intuition or principle, we often feel we have different types of obligations, positive obligations towards people, that depend on the nature of some prior relationship between us. So, for example, most of us will say that we have a greater degree of obligations to help our family members than random acquaintances. That if, I don't know, your parent is dying or is unwell, you have a greater duty to help them than some other unwell person on the street. That you have a greater duty towards your friends than towards, say, a homeless person you encounter on the street and you don't give them money. That you might have a greater degree of positive duties towards your co-religionists, co-nationals, members of your neighborhood, members of whatever community, than towards people half the world away. So these are intuitions that are shared by a lot of people. I'm not saying necessarily they're valid, but they are what they are. And in particular, when it comes to states, there's a sort of generally accepted idea that states have a greater degree of duties towards their own people than towards others. So let's work that through some scenarios. Here we run into one of these new models that have been argued for in the literature, or for example, by the UN Human Rights Committee or the Committee on the Rights of the Child, the so-called functional approach to jurisdiction, which basically says something like, if you have the capability to help somebody, you should help them. Yeah? So listen to the following scenarios. This is the simplest one. It's again about killing. State A acquires intelligence that state B will kill somebody on their territory. Does state A have a duty to warn the potential victim? Not do anything more than that. Just tell them, hey guy, we think you're gonna get assassinated. I'm not giving you a hypothetical. So this is Jamal Khashoggi, for example, being chopped to death by Saudi agents in Istanbul. This is that type of scenario, where the Americans actually kinda knew, because they intercepted phone calls by Saudis and so on that laid out the plan, but the phone calls were never processed by intelligence agents. So they had information in their possession, but they didn't know about it, the Americans, yeah? But we have many, many such situations. So do we think that Italy, for example, if Italy knew that authorities in Libya are gonna kill somebody in Libya, that we have the duty to warn that victim? If you think the answer is yes, that opens up a lot of different possibilities. If you think the answer is no, all of these other possibilities get shut down. If you think a person is being subjected to a cyber attack, say a journalist in another country, do you have a duty to help them? If a state knows there's a famine in another country, do you have the duty to share food with people in that country? If you have vaccines against a new virus, do you have a duty to share vaccines with the population of some other country that does not have those vaccines? Again, not exactly hypothetical, yeah? Are you allowed to prioritize your own population? If you think there's that duty, are you allowed to vaccinate your people first before you share it, before you have to share it with others, yeah? And now this brings me to the C. This is the AS case, yeah? So you're an Italian naval vessel. 5 meters away from you, you see a dinghy full of migrants who are gonna drown. Do you have a duty to help them? Do you think that duty really depends on whether you're in a SAR area or not? So imagine if the Italian vessel is not in the Mediterranean. Imagine if an Italian vessel, by the way, Italy has a carrier, an aircraft carrier. Imagine if that carrier is in the Pacific, and there's a boat full of people in the Pacific who are drowning. Does Italy have a duty to help those people or not? Does that duty depend on whether you're 5 meters away, 50 meters away, 5 kilometers away? If you're at the scene, as some of the members of the Human Rights Committee argued? Or does it simply depend on your capacity to actually do the rescue? And if you think it only depends on that capacity, that means states have to do a whole lot of things, yeah? Include, sharing vaccines and all those kinds of things. So I hope that makes sense. These positive duty scenarios are really, really, really the most complex. We can distinguish between them within that group, between those scenarios where somehow a state contributes to the cause, to somehow the root cause of the problem. So, for example, should the UK have a special duty to repatriate or to relocate former members of the Afghan Special Forces or translators who worked for UK forces in Afghanistan, and for that reason, the Taliban want to kill them now? So this is the kind of situation where there's a special dependency or special relationship of some kind. Do we think those scenarios are different from the ones I just explained? Does Israel owe a greater duty towards the people of Gaza, for example, than it owes towards the people of Fiji? And why? Yeah? Does the UK owe a greater degree of duty towards places it wrecked, like Iraq, Afghanistan, Libya, as opposed to, I don't know, Serbia? Or, do you have greater duties to mitigate climate change if you are a great emitter of carbon historically? So those are the positive duty scenarios. And again, I don't think the sea is special argument works for sorting those. If you want to have an expansive view of positive obligations on the sea, you have to apply that consistently to all of these other issues as well. Thank you so much.
Thank you very much, Marko Milanovic. I couldn't think of anything better as a moderator than someone saying there's nothing special about the sea in a room with eminent law of the sea lawyers. I very much look forward to this discussion. So your proposition is that jurisdiction, we need one theory which applies across domains, land, sea, cyber, whatever domain. However, you also acknowledge that maybe we cannot have one theory, but we need at least to have a distinction between positive and negative obligation. I guess that sets the scene very nicely, and without further ado, I would like to give the floor to Professor Violeta Moreno-Lax, who joins us online.
to avoid double standards from emerging, which is a consideration that the Human Rights Committee, but also the European Court of Human Rights in ISA and others versus Turkey, for example, already formulated as a concern that would stem from the fact that otherwise you would be given like a carte blanche to states to go around the world doing things that they would not normally be allowed to do when their power is confined within their territories. So the concern that we are trying to address in SS, and so from where my thinking stems, is this observation of techniques of contactless control, as I've named them, that render the border fluid, dynamic, multiple, and meta-territorial, so projected beyond the physical domain of the state, being offshored, outsourced, digitalized, whatever the mechanism that you can think about. The result at the end of the day is that this means generate a distance, not just legally important, but also apparently morally important too, in the sense that through that distance there appears to be an excuse for states to diffuse or deny the responsibility that otherwise would attach to their actions. And so there are different techniques through which this border techniques are experimented and exercised. So we've mentioned already a few, so I'm just recapping. But think about aerial refoulement, which is facilitated by the sharing of information via drones or other forms of detection with actors around the world, be it, a third country or a military guerrilla movement or a mafia that dedicate themselves to trafficking people, for example. Or think about the utilization of merchant or fishing vessels to orchestrate and carry out pushbacks in a privatized form of it. Or think about the intermediation of an agency of the European Union. In these cases, we have seen in the Mediterranean, Frontex being the paramount example here. Or think about the utilization of a proxy actor through which a pullback operation is orchestrated or conducted via delegation, right, on behalf of a country of destination. That what it's attempting to do is that people do not touch base. They do not activate the territoriality of the border that would normally activate the human rights obligations that attach to it, or that are normally construed as attaching to it. So why techniques of contactless control are seen as potentially responsibility neutral, at least, as states around Europe particularly and in the Mediterranean context go, because the premise under general international law, and I'm drawing here from the Arsiwa articles, is that the legal causation that matters in situations of complicity, as Marko Milanovic has mentioned before me, is that you need that this, the action that generates harm is attachable to a state that is exemplary of state conduct, but that this attribution or this attributability is such not under simply a factual assessment of the circumstances of the specific situation, but also under international law, meaning that what we are after here is a construction of causation that is legally mediated. So we are paying attention to legal causation, so causation that is significant under the law, not any forms of factual causation. At least this is, I think, the reading of some countries, and particularly the Italian government in the SS case. So this is very convenient because it can generate accountability gaps. If not all causations are generative of responsibility, if they're not generative of attributability, it can be used to eschew, to reject, to diffuse responsibility. And to a certain extent, a reading of Article 1 of the ECHR that considers that the legal causation element that needs to be fulfilled is that people need to come within the jurisdiction of the state for the state to have obligations towards them is possible. So the generation of this accountability gap is not really unfathomable under the terms of both Article 1 of the ECHR and this reading of the URSIWA as only concerned with legal causation rather than factual causation. So this is how I think we end up in a situation where we need to, abandon basic intuitions about how the normative link between states and individuals for the generation of human rights obligations is generated, and we need to try to understand the legal meaning of jurisdiction for the purposes of the generation of these human rights obligations that stem from Article 1 of the ECHR, but also other instruments of international human rights law. And so in the basic reading of this, particularly after Bankovic, but I think also before and certainly also afterwards, we see that jurisdiction is understood as a threshold criterion, that it's necessary for triggering human rights obligations, without which acts that would violate, presumably, rights of individuals would not entail responsibility. So jurisdiction is the key to the door that opens the legal causation chain that can lead to the establishment of responsibility, and without which the obligations are not set to become applicable in the first place. And so what the European Court of Human Rights has done now in a quite isolated position, in that other UN treaty bodies and other courts around the world, particularly the American bodies of the Inter-American Commission and also the Inter-American Court, have sort of embraced a more progressive understanding of extraterritorial jurisdiction. We see the ECHR being a more conservative body in this regard, in that what they latch onto is a territorial conception of jurisdiction that would see jurisdiction related somehow to public international law notions of it, which are not pertinent or are not really nothing to do with the determination of whether or not obligations are owed to individuals, rather than, as has already been said, there was title or not to act in certain ways under the rules of international law. But be it as it may, and I'm reading now what things that Marco has already mentioned, the two standards tests that the European Court of Human Rights has used to determine whether extraterritorial jurisdictions exists or not are the territorial model and the personal model, both of which pivot around the notion of effective control. But what happens is the court has never really engaged in a definition either of jurisdiction or of effective control. So we don't really know exactly what counts as effective control. Is it only de facto control? Is it only direct physical power that is exercised over persons or territory, as the case has been in cases engaging occupation, detention, arrest, abduction, extradition, extraordinary renditions, and so on? Or are other forms of indirect or indeed contactless control also relevant? So, for example, if we are talking about a maritime blockade, if we want to make an example that is pertinent to the sea context, would that amount to an exercise of effective control, even if there is no physical contact and no physical encounter between the state and the vessel that is being impeded access to territorial waters? Would that be enough? We don't really know. There hasn't really been a case in this regard, but there is this admissibility decision, Women on Waves, where the court appears to assume that that is indeed the case, since there is no discussion on this point, at least not a full-length discussion on this point. The point is just taken for granted in a way and assumed that it is indeed the generative of effective control, a maritime blockade. But what about elements of the jure authority that are prescribed by public international law? And here again, in a piecemeal fashion, we have part of the answer as being delivered by the court in Hirsi, for example, following in part what we have seen the approach of the Human Rights Committee has been in NAS versus Italy. So for instance, search and rescue obligations under the Maritime Conventions or the Law of the Sea, the Saran Solas Convention, or Article 98 of UNCLOS, because they do generate positive obligations in that other system of rules, that has been understood to be pertinent for the understanding that there was an obligation of human rights under the right to life that was hooked on the jure authority that was prescribed by public international law, that rendered activable the responsibility of the state concerned. But in any event, I mean, all of this is patchwork, piecemeal in the approach that we see the court adopting, and that has led to gaps and inconsistencies, part of which have already been mentioned, in situations that entail, for example, one-off instances of killing or bombing, depending on the circumstances. And so Bankovic, although we thought of it as an outlier, or at least as a politicized precedent, we have seen a reenactment of this in Georgia versus Russia, for example, like a couple of years ago. So it doesn't really appear to be settled what effective control is and how it is established according to the court. The difference may be in the normative ties that sort of generate a public power link between the state and the victims. That might be it. We don't know. The court hasn't really provided principled reasons or really explained their arguments that would, for example, differentiate the situation in Alske-Ini from the situation in Bankovic, or indeed Georgia versus Russia, right? So in Alske-Ini, against the background of a UN military mission, we have a situation where there are several killings that happen during the deployment of this military mission in Basra, the part of the country that it's not exactly under full occupation by the UK, but the UK has a presence that has been authorized at some point by the UN Security Council, and then it appears that there is a title conferred under public international law that the court appears to consider relevant for the establishment of a jurisdictional link in the particular situation. And so among the different killings that happened during this military mission, there is a random killing of the wife of a passerby that gets killed by a random bullet. And because this happens against the background of a security mission that the UK is undertaking, that is understood to be sufficient to establish the jurisdictional link that generates obligations vis-a-vis this person. And this contrast with the situation in Bankovic, where we have a killing through a targeted aerial bombing that the court thinks is not, on the other hand, generative of a jurisdictional link. What is the reason for this distinction? We don't know. In Georgia versus Russia, chaos that appears attached to the active phase of hostilities in a situation of armed conflict seems to be the element that distinguishes these two situations. But I mean, this is me reading maybe too much into the ruling of the court. The court doesn't really explain what might be the distinguishing factor here. So we are in a situation where we cannot really anticipate when and how effective control is going to be defined to exist by the court, and what are the elements of de jure and de facto authority that count towards the definition of that control as effective. And so coming to SS, which entailed a violent pullback executed by the Libyan Coast Guard on the high seas, but under instructions provided by the Italian Maritime Rescue Coordination Center in Rome. And we have proof of this. I mean, there's been a factual reconstruction by forensic oceanography, which is super detailed and based on different sources collected by different actors, including Sea-Watch, which is the NGO that intervened in this case. I mean, it is the case entails not only a violent pullback executed by the Libyan Coast Guard, but also a violent encounter between the Libyan Coast Guard and Sea-Watch, both of which were in the region where the shipwreck occurred, and both of which received the signal, the Mayday, and instructions confusing as they may have been, but they both received instructions to proceed to the rescue by the Italian authorities. And so when they came to the scene, there was confusion as for what exactly they needed to do, who needed to act, how to undertake the rescue. And as a result of this, several people died by drowning, but also by the incompetent actions of the Libyan Coast Guard. All of this is captured in video material collected by CCTV, footage of Sea-Watch. So there's plenty of evidentiary elements that can be used to display the chain of, in factual terms, of the causal link that would tie Italy with the harm that ensues from this interaction. So what we are proposing here is that because the situation stems from a functional projection of the border by Italy, engaging with the Libyan Coast Guard to execute actions on the high seas that, if executed by itself, would have generated human rights obligations, as in the Hirsi case. There needs to be, there isn't really a reason why, in a situation like this one, Italy should be considered capable of escaping its human rights obligations. And so we are proposing a functional model to the understanding of jurisdiction, whereby all manifestations of public power, including those that relate to border control and that are normally executed by a sovereign government, in this case Italy via ex proxy Libya, are a manifestation of state functions being discharged through different elements that can entail de jure and de facto actions and omissions, which in combination give rights to the result that we see materializing in SS. So what we are trying to convince the court of doing is to embrace an understanding of control, effective control, as the control that is determinative of the material course of events, even when it is exercised from a distance, judged against its influence on the resulting position, legal position, of the individuals affected. And this is not unheard of. ITLOS, for example, in the North Star case, has embraced a similar position. So we're asking the court to draw from existing jurisdiction and existing normative intuitions that others already have manifested in different ways, and to embrace a more coherent and more cohesive understanding of effective control for the triggering of extraterritorial human rights obligations. And so this is a little bit the scheme that I've tried to develop further in my writing. This is not exactly what was submitted to the court in 2018 and 2020 when we wrote the observations on behalf of the applicants, but this is a bit what I think I'd like to test, and I'd be very happy to receive comments and observations on this. So there are different causal links, as it were, in situations like this. In situations of extraterritorial control, where you have a state that projects its conduct via an agent, conduct that is generative of harm and that affects the rights of an individual. So one section of the relationship is captured by causation, the effective control model that the court has been focusing on, be it over territory or individuals, and to a certain extent in the positive obligation cases also over the source of harm. But there is also the other part of the equation that would look at what the ARIO and ARCIWA and international law at large might configure under the term of attribution. So the conduct can be linked back to the state from which it stems, or for the benefit of which it is, or on behalf of which it is undertaken. And this conduct may be determined by contextual elements of a de facto or a de jure nature, right? And in any event, what matters, at least for my understanding of it, is that this conduct is an expression of public powers. So the conduct that matters is the conduct that can be traced back to the state, because it is a manifestation of the state's authority understood as an attempt at imposing its will over persons abroad through whatever way the state may choose, be it via its legislative, executive, or adjudicative activity that needs to be considered in the aggregate. This is, I think, what ITLOS does in the North Star case, and is the part of the effective control or the jurisdictional equation that the court has not elaborated upon and that remains unclear. It's a little bit of a black box. We don't really exactly know what authority means for the court and how it is established and what are the normative elements that configure the nexus that tie a certain individual with a certain state. And that is absolutely necessary to be understood so that then obligations vis-a-vis a particular individual are owed by a particular state, right? So if we can reunite these two sides of the equation and take them both into account, then jurisdiction becomes the sovereign authority nexus between the state that exercises conduct in the form of an action or an omission or a combination of both, conduct that takes on the form of legislative, executive, or adjudicative activity, and which in any event is an expression of the powers of the state. So it's conduct that is public in character. And if that conduct then it's also determinative of the course of events that leads to harm that is human rights relevant, then I think we should be able to provide a general definition of jurisdiction that works across scenarios. And this is what I think the court should understand in situations of complicity like the SS case. But I think this is transposable also perhaps to situations of positive duties. I mean, I have done less thinking about this, and I'd be curious to know what the rest of the panel thinks and what the audience thinks. But for complicity scenarios, I think this model works, right? So in the scenario of SS, we have this pullback operation by the Libyan Coast Guard on the high seas, the Libyans acting as a proxy of Rome against a background where Italy and the EU, for that matter, are providing capacity building to the Libyan Coast Guard, to the point that the Libyan Coast Guard would not exist if it wouldn't be for that support that Italy and the European Union are providing, so that the end result of a harm in the form of refoulement by proxy would not exist if it wouldn't be for the input on the part of the Italians and the European Union at large, but Italy for the purposes of the case. So if we look at the wider picture, there are legal political elements, funding and equipment and operational involvement, all of which I think are manifestations of the public power that Italy is exercising in the background that lead to the chain of events that materialize in the harm that the victims in SS have suffered. So we have a number of treaties, memoranda of understanding, declarations that endorse this form of cooperation between Italy and Libya, despite the human rights situation in Libya, which is well known for many years now, but particularly so after the targeted killing of Gaddafi. There is an enormity of funding that is transferred from Italy that constitutes... Yeah, I'm coming to an end. This is really my
close. Thank you.
Yeah. So there is funding that circulates from Italy to Libya, and there are also operational elements of involvement of the Italians in the Libyan way of doing things, right? So Italy has been securing search and rescue responses within the Libyan search and rescue region since the Arab Spring, and it has been assuming command and control functions through its operation Nauras, at least since August 2017. So all of this, if taken holistically into consideration, should be constitutive of functional jurisdiction. So if we embrace this understanding, hopefully this will entail a change of approach, and the ECHR, whereby the court would adopt a coherent test that would apply across the board and would provide coherence to Article 1 ECHR at large. It would require adopting a functional understanding to the normative sovereign authority nexus that links individuals to states, and it would require looking at how states exercise their powers that are public, and this is the main issue, via different plethora, or a different array of possibilities, including legislative, executive, and judicial possibilities that need to be taken into account holistically. We'll see what happens. I mean, the phases of observations, counter-observations, and all of this is long been closed. We are waiting now for an admissibility decision. We'll see what happens. Maybe there is a relinquishment to the Grand Chamber. We haven't yet been communicated any of this, but let's wait and see. So thank you very much for your attention, and I'm looking forward to the further discussion with the panel and the audience. Thanks a lot.
Thank you very much, Professor Violeta Morena-Lax, for your presentation. Similar to Marko Milanovic's presentation, we have this claim for a more coherent approach, for a principled approach, because the piecemeal approach currently pursued or existing leaves many gaps, and you also demonstrated how strategic litigation can contribute to the evolvement of jurisdiction. We have seen this morning, it's a concept which is not static but dynamic, and we are curious to see how the court will decide. I will now give the floor to Lea Reible. She will speak on capacity and control over the source of harm, new avenues for jurisdiction in international human rights law at sea. Thank you for coming.
Great, thank you so much. Irini, thank you so much for the invitation. Thank you all for being here and for your attention. I also lied on the program. I will be speaking about all of the things that I listed, but in the opposite order. So I will start with jurisdiction, then speak about control over the sources of harm, and then about capacity, not the way the program says. Could we change slides, please? The structure of my talk follows this outline. I will first say something about jurisdiction as political power. This is a view I defend in my book, but it is also a view that says a little bit more about the reasons why jurisdiction looks the way it looks in international human rights law. So it's focused on normative foundations rather than factional scenarios. I will draw out in the next point in my presentation that one of the main points of construing jurisdiction as political power is its potential for comprehensiveness, and that it can be applied in a principled way. So I agree with Marko in this particular instance, and think principled application of whatever model of jurisdiction we're preferring is very important, is crucial, in fact. I will then say something about context, nevertheless. There are ways in which the sea could be special, not normatively, but factually. And how this factual division between land and sea, and this factual division between different scenarios, could come into our account of jurisdiction nevertheless, even though it's a factual consideration, not a normative one. And then I will say something about what all of this together could mean for jurisdiction as political power at sea. And I will explore power over sources of harm, as Violeta has just mentioned, and capacity as vehicles, so to say, or new conceptualizations that could potentially modify this account to take to consider the factual peculiarities of human existence at sea. So if we could change the slides, yeah, that would be lovely. Thank you. Jurisdiction as political power. First, I would like to endorse everything that Marko has said about the characterization of jurisdiction in international human rights law. It is, in fact, about the identification of a duty bearer. So which state owes which duties to what individual. That is what we're talking about. Why do I not go for a description that goes with the case law in that it focuses on the territorial or state agent control model? So the reason here is that power is a potential and that jurisdiction can be established without anyone doing anything at all. Often, for example, the territorial state does nothing other than exist and yet has jurisdiction over the people within its territory. I'm not saying that the other models do not agree with this. I think they do. It's a point of emphasis that I want to make, particularly to avoid confusions between jurisdiction and attribution for state responsibility purposes. Now, why political power? Political power is another way of putting, or I thought at the time, I'm no longer sure whether that's true, but I thought at the time a better way of putting the concept of public power. So what does that mean? Public powers are public in the sense that they transform individual powers to then do things together in a way that private powers cannot. This is, for example, done by regulation, by coordination, that makes this political. Now, power is a potential, but it can also be exercised, and it's exercised through vehicles. The exercise of political power results in the control over human activities. Which human activities are relevant? It's those that are outlined in the human rights treaties in the substance of the rights outlined there, so freedom of expression or liberty and security or the right to health or food. The vehicle through which this is done is the choice and application of rules. Now, this does not have to be formal legal rules. It does not even have to cohere with or abide by domestic law. It just needs some rule-based systematicity to it. That's roughly what I think jurisdiction should be understood as when we say jurisdiction as political power. The image, by the way, that you're seeing, I know it is not obviously connected to jurisdictional questions, but it is an aerial photograph of Kyiv Oblast, roughly where Russia went through when it tried to take it. So it kind of is anyway. Next slide, please. Now, why did I go for this account specifically of jurisdiction? It focuses on any agents or states, in particular, ability to guarantee equality. This goes hand in hand with the purpose of international human rights law. It's very much based on the idea of both preserving autonomy, preserving well-being, but doing so equally. And because of this, not any kind of exercise of power and not any kind of harm or not anything that causally impacts how a human life goes is also relevant for international human rights law. So the political power bit that characterizes jurisdiction through vehicles and exercises and reasons, basically, tries to capture this aspect. Now, usually, this will be held by public institutions, and in that sense, it makes it public, in the public powers kind of model that Violeta mentioned. However, it does not have to be only held by public institutions. We can imagine situations where private operators of anything, for example, because they're the only employer anywhere, or for example, because they're a fishing company who have a ship that is sailing through the seas, could take on a very similar function that looks a lot like political power over individuals. So it does not, even though it looks like it's a model only for state jurisdiction and the establishment of that, political power does not have to be that. It can include the establishment of obligations for non-state actors, although in a limited fashion. I understand this is of particular concern in the context of the law of the sea, where often states are not involved at all, other than as flag states. The main concern of this model is a recognition of basically what Marco has said about positive and negative obligations, or mainly positive obligations of states in international human rights laws. Like, these are complex. Often the stakes are interdependent, and because we're talking about institutions, even negative obligations are actually positive obligations, because states are not people and require coordination to do anything. So even negative obligations require doing quite a lot. So this is always a problem, not just for what is recognized as positive obligations to protect, for example, human rights against the interference by private actors by managing risk and regulating appropriately. So that's the main concern of this account of jurisdiction. Could we change slides? Now, I'm not a law of the sea person. I did think about, well, what does make the law, what does make the sea special for the purposes of this presentation? And I think it is special, but not for a normative reason. So I would like to just relate this bit of my presentation to what Marco has said. One of the problems that human rights institutions face when they decide cases is that their reasoning needs to be very good, because they're deciding cases against the very actors that sponsor and fund them, the states. This raises the bar for how well they explain what they do. So consistency and principled application of whatever they do or decide is really important. That's because their authority, as in a fundamental way, depends on the content of their decisions. Now, this is not ideal for legal institutions, but for quasi-judicial bodies in international human rights law, it's just the case. So I agree that it is of crucial importance to find a jurisdictional model that in fact applies across scenarios and that applies everywhere, and that we can extend or not extend depending on principles, rather than, oh, this seems a bit terrible if we can't do anything here. That's not a good reason to extend legal responsibility. Now, sometimes, though, we can remain normatively principled and take facts into account in a normative account. So that's possible, and the kind of facts that I had in mind here, and again, I'm not a law of the sea person, so bear with me, but I do believe at least one of the things that I mentioned here was also touched upon in the morning. So the ability for control at sea is reduced, at least in some senses. Nobody knows exactly what's going on a ship in the high seas, right? I've never been on one, but if I just imagine what that's like, I'm imagining if we're saying, well, you need to have control in the sense that you need to have on land, that doesn't, even though that looks principled, it actually isn't, because it's not possible anyway. And so, in fact, applying the same threshold in some senses would not be valuing human lives and people equally. Equality being a concern that I have and that Marco also has. So the ability for control is reduced, and one of the reasons why is that human survival at sea depends on equipment in a way that it does not on land. And this, coupled with the isolation of often of the isolation of these incidents, I think warrants at least thinking about, well, what kind of difference would these facts make? And that's what I try and do in the rest of the presentation. Can we change the slides? So, power over the sources of harm. I've chosen power over the sources of harm and capacity because these are two models of jurisdiction, or two additions to jurisdiction in international human rights law that are currently discussed, either implicitly in case law or explicitly in the literature. The power over sources of harm is discussed not just, as Violetta has mentioned, in relation to migration, both at sea and not at sea, but also in relation to climate change. So if you're a major emitter, and you have historically been a major emitter, should that change your jurisdiction over people who are now impacted by climate harms, even though they're somewhere else? There are two problems, I think, with the power, with shifting the focus on the power over sources of harm. First, because it is really a major shift in what is established law and thinking about this. This is not a problem in and of itself. Major shifts can and do happen, but it is one with just major implications. It would, for example, take away almost entirely the focus of jurisdiction that it currently has in establishing a relationship between the duty-bearing state and the right-holding individual. Because the right-holding individual would be created by being harmed either deliberately or not, as in the case of climate change. So it also mixes the harm with the potential. So we are no longer in the area of power as a potential. And that can be difficult. But it has been implied in the Inter-American Court of Human Rights advisory opinion on human rights and the environment. And now how could this, so it's not outlandish to speak of this. It's around, it's out there, it's not very well formed, but it's worth thinking about, just acknowledging the problems as we go. So at sea, how would this apply to states? How are states who might encounter people who need protection at sea, how do they control the sources of harm? They do not control the fact that the seas are a difficult environment to survive in for humans. That's not the source of harm that I mean. There is another source of harm, though. It's the regulatory framework or frameworks that apply. Over lunch, I was told that the UN Convention on the Law of the Sea has a lot more to say about fish than it has about fishers, for example. So that would be a source of harm for the protection, or that would be a source of harm for fishers. We could also point to the existence of exclusive flag state jurisdiction and flags of convenience. If they exist at the same time, that creates problems for the protection of people at sea, as I think was pointed out this morning, and that is a source of harm. It's not a practical source of harm, it's not a gun, it's not a drone, but regulatory regimes can also be harmful. Anyone who thinks about modern slavery and immigration regimes can say something about that. Now, in isolation, as a model for jurisdiction, if we just think, well, it's enough if a state controls the source of harm that was at play in the scenario considered, this is normatively very attractive because indeed it does close a lot of accountability gaps. And it gives an avenue and standing to individuals in international law that's unparalleled and in that sense beautiful. It is also practically really difficult, and for the reasons that I've pointed out in the beginning when I started mentioning this. And it will be difficult for human rights bodies, especially the most prominent one, the European Court of Human Rights, at least in Europe, because its judgments are binding, and so it matters whether or not they extend obligations or jurisdictional thresholds. So I see some practical difficulties if that major shift is envisaged on its own. Could we change slides? And this is where capacity comes in. like Marco, I mean, if I understood you correctly, you're skeptical when it comes to capacity alone as jurisdiction? Okay.
We'll talk about it later.
Good. So we'll talk about it later, apparently. It's, again, this is normatively very attractive, and it is already around in the Human Rights Committee's decision in ES and other sources. Italy, I'm sure we've heard about this. So if you can do something against something bad happening, you should. If you can rescue somebody, you should. If you can stop greenhouse gas emissions, you should. If you can help climate adaptation, you should. Often this will be in the law of the sea context, or in the context of the seas. This will be about intervening, rescuing, doing what seems at least immediately or reasonably necessary. It varies. I looked at the various decisions out there, and I'm not quite sure what it would mean. But in any of these cases, so the less that is required, so the more immediate it needs to be, what needs to be done, the less problematic it is. But it means that there are potentially far-reaching positive obligations for minor involvement, or no involvement at all, just capacity on its own. Justification, again, like the sources of harm, will be a problem. However, if we now say, we could go for a combination of the two and say, if you have more involvement in the power over sources of harm, your capacity plays more of a role. So you need to do more the more you're involved in the control over sources of harm. And if you modify those two together, that gives you a sliding scale of jurisdiction. So more fault, more jurisdiction, roughly. Again, justification will be difficult, but it would be a solution, I think, for those who are convinced that we need a principled account of jurisdiction. Also think that the specialness of the sea or the specialness of climate change or the specialness of anything should be taken into account. And think that currently the account or approach to jurisdiction is too restrictive. This is one way you could go about it. If you argue like this, you can take into account the specialness of the sea or climate change. You can make a good argument as to why it should be taken into account and still have a principled normative approach. And this leads me to some conclusions. If we stay on the jurisdiction as political power, that's strong on justification grounds. It's relatively stringent as a threshold for jurisdiction. Many cases that I would like to include, that many of you probably would like to include in the jurisdiction of states, will not be included. There are potential weaknesses at sea because control, the ability to control, which is, remember, the outcome of political power when it is exercised, is limited. But if it is then modified through including notions of power over the sources of harm and capacity in this sliding scale, the connection being that the power over the sources of harm here is very public in its nature because it is a power over a regulatory framework. That would give an avenue, a new avenue, as I've promised, for the jurisdiction of states to protect human rights at sea. Thank you very much.
Thank you very much, Dr. Reivle, also for taking the challenge to consider the seas. You have mainly worked in a shore-based context, so this is always of added value if someone gives a fresh look to subject matter. also an interesting middle ground that you mentioned, that maybe we need to remain normatively principled and have one normative framework for the seas and the land, but that there's the possibility to take into account differences at the level of facts. So that's a middle ground position between there is no distinction at all and we need to treat it differently. With this, I would like to give the floor to Dr. Christophe Gombert, who will speak on gaps and overlaps. To what extent can primary rules of international law inform the allocation of human rights jurisdiction? And there we will deal with the interaction of different bodies of law, human rights law, and public international law. The floor is yours.
Good afternoon, everyone. Thank you for the organizers. It really seems on this topic we have actually founding mothers, which is kind of cool. I try to cater with the presentation actually also a bit for the students and at the same time the expert audience, and I hope I will find the right balance. In my title, you will see, and maybe sometimes unconsciously, I will do this when I use the word jurisdiction. And that is because I think the way we have started using it leads to a lot of confusion. I started using the word relation of duty, but I thought I'm not going to start on all of that because then I need at least 2 presentations and you will never want to see me again. So I hope I will therefore still use the most common way of talking about this, and that is to use the term human rights jurisdiction. Of course, agreeing fully that it has different meanings. Where do I click? So when I think about human rights, I do think that we can think on the one hand the human rights of the people that you and I have by virtue of being human, and that we can think about different potential duty bearers, and that really whether obligations are triggered really and what kind of obligations are triggered depends on how the relationship shifts from being horizontal, you to me, a matter of perhaps ethics, to really a power relationship to the states, but we are talking about the state today, and that's where the focus of the rest of the presentation will be on. So the term needs no introduction anymore. We're talking about human rights jurisdiction, and the essential really underlying question there is, for human rights purposes, what kind of relations between the states and individual really matter now for triggering obligations. And so just schematically, so that we're all clear and on the same page, we are talking about the threshold or the preceding exercise of establishing human rights jurisdiction before we actually look into the content of the obligations, what went well there, because sometimes it goes well, or most of the time also it goes well, and what goes wrong. And of course, causation has a role there to play, but as I will try to highlight a bit in the presentation, causation also can have a role in this first phase. So we're talking about the triggering of human rights jurisdiction between a state and an individual. When you look at the case law, one way of modeling what is going on is area versus state agent control. You can also distinguish it by really focusing on the nature of the relationship and what is going on there. And so you can say that some relations are characterized by legal powers of the state, and then the question is like, over what or over whom? And then you can have a narrow view and say it must regulate the situation of the victim, but you can also ask the question, is the state using legal powers regulating, enforcing, adjudicating the source of harm, or any stake that is connected to the rights of the individuals affected. A thing with this model in the case law, it is the most common one. It never leads to any jurisdictional issues because it mostly happens on the territory of states. It's the state applying laws leading to disputes and so on. This can be accompanied with physical control, but that does not need to be the case. Then another way of triggering relations of duty or human rights jurisdiction is by factual powers of the state. This is a series of examples that Professor Milanovic gave, I think, when it says it doesn't matter whether your action is rooted in a norm that you seek to apply or enforce. It is about factual power. These things we also find back in the case law. And then most recently, and as it's started clearly to crystallize during the talks today, is causal powers of the states where they produce effects or actually have the capacity to produce effects, but maybe refrain from doing anything. So then we're talking about emissions. We start seeing this in the case law as well, even if there's an absence of these previous two types of relationships. So even in the absence of authority or control. It's about the latter that I want to talk for the remainder of the presentation. And so what is an obvious advantage of this causal powers model? That is that it closes potential legal black holes. Difference between a legal black hole and a de facto black hole, as Itamar Mann explains in one of his articles, is that with a de facto black hole, you do have a duty bearer that you can identify, but that duty bearer doesn't live up to it. While with legal black holes, you initially have no ground for establishing a relationship of duty for any state with an individual. And that is a risk you might have, for instance, on the high seas, and what in that sense maybe makes the maritime domain special. It is, of course, controversial. It clearly expands the notion of human rights jurisdiction. And it is very complex and leads to legal uncertainty, as has been clearly illustrated. What kind of effects matter? Do emissions really matter? And if so, on which conditions? And in that, how do you draw the line on what is then a causal spectrum? The illustration of, are you 500 meters away, 5 kilometers away? It is really the Peter Singer problem of the drowning child. If I walk past the pond, I ought to wade in, and his whole work is about if I live across the USA and it costs me the same, I should still be a duty bearer. But it leads to very complex issues, and I thought to now further zoom in on how we can deal with that, and at least how the case law seems to deal with that. And so it's been mentioned a few times today, the AS and others versus Italy case, where the complaint was about the violation of the right to life, both on a substantive limb and a procedural limb of the right to life. So substantive limb means you did something or did not do something that actually led in practice to the loss of life. Procedural limb is more about the obligations of the state to then investigate, prosecute, deal with the consequences. So in this case, there was a distress situation in the Maltese SAR zone, and almost everything that can go wrong went wrong, or everything that should happen happened, but too late. And so the thing is, first of all, and this is where the causal model comes in the absence of authority or control, is, first of all, these SAR zones, to the extent that they are overlapping with high seas areas, at least according to the International Law of the Sea and the specialized SAR conventions and so on, they do not create authority of the state, the coastal state responsible for the SAR zone, vis-a-vis foreign vessels in that zone on the high seas. It leads to requests for cooperation reminding captains under their national law of the flag state to please proceed to a distress scene or to please refrain from proceeding. But SAR zones or the role of a first RCC, that is when a state is not, according to the plan, the one that should be doing the coordination, but then is the first one to pick up the phone. They have to coordinate until the de jure responsible one actually takes over. There too, it's the same. Over foreign vessels, they have no authority, and a fortiori, you can say that, yeah, also no authority over the persons that are in trouble. Same with factual control, unless they started investing in a huge drone system and strategically putting patrol vessels everywhere, they have no factual control over what are actually vast areas at sea. And so neither over the area nor over the persons. Again, you can have discussions of what control amounts to. Those happen also in dissenting opinions. But arguably, control, if you say it's the probability that I can affect the outcome here, control is where your probability P is closer to 1 than to 0. And I would say here, controlling a situation, your number would be closer to 0 than to be in these complex, vast areas. So what was an option? Italy and Malta had the ability to affect the situation, each in their own way. In other words, they had causal powers, absence, authority, and control. But it sounds nice when you start about it, but then it leads to rabbit holes, because which causal powers matter for triggering human rights jurisdiction? If you look at the case law, the Inter-American Court states relatively vague. It talks about a causal connection can suffice. Human Rights Committee uses reasonably foreseeable effects. And as already mentioned, European Court of Human Rights is more strict, talks about isolated, specific, and proximate effects. When you look at those formulations, I would say they all turn around factual elements, looking at the facts and what does often like a person think is proximate. I think this is full of normative bias, how you look at it. Someone who has studied sociology and substitution effects of migration patterns will see different causation and closeness in a case like this than someone who has not read this literature. So anyway, Professor Milanovic mentioned it today, but when the case came out, he did mention like how do we dispense with arbitrary law, line drawing, and the functional answer. And again, it seems just like jurisdiction, functionalism also starts having its own life and different avenues, but could be what can you reasonably comply with? Again, I would say that's still very problematic, and I would ask, can there be any further normative guidance? And so, when it comes to the other two models, namely the authority model and the control model, we do sometimes get help from international law because they create presumptions regarding the existence or absence of authority or control, or both, in the relationship between a state and an individual. And I think this is where I will put my hands behind my back and I say, this is an awesome context to use the term jurisdiction, because it's actually connected to what that concept is for, namely when does a state have authority, when can it, and sometimes under international law, when must it exercise authority. When it comes about enforcement, again, when can a state exercise control? Well, these rules, which Herbert Hart would call power conferring rules, or you can call them secondary rules, they indicate when a state, at least de jure, should be having or can be assumed to have authority and or control, and when not. So think about territorial sea ships, flying the flag of the state versus foreign territory and the high seas. I don't know how I am doing with the time. 7 more minutes. Should be doable. So what you could ask is, can in the same vein international law play a role for the causal model? And so can presumptions be made regarding effects and omissions by relying on rules of international law? It's maybe a bit of a weird question, or maybe you don't find it weird at all, I don't know. But then the category of rules that would play a role, arguably, are not secondary rules, but what Hart would call primary rules of international law, not rules that create not powers but impose obligations to do something or not to do something. In other words, an emission is problematic in light of those obligations, or producing effects, creating effects is problematic in light of those rules. At least this is what came to my mind when the AS came out. And yes, the developments in terms of what kind of factual elements matter in triggering human rights jurisdiction under the causal model are really out there. They're really in your face, and you can see developments. There was a lot of commentary on it, and you can say, okay, this is a progressive development. So there was initial contact made, in this case with Italy. There was close proximity of an Italian vessel. There was ongoing involvement of the Italian MRCC in the operation, and so at least that part the committee considered as, hey, this is normatively significant, even in the absence of power or control, even though lawyers would still continue to say, oh yes, so therefore there is effective control, which I would like, no, in terms of control, your probability is closer to 0 than to 1, but okay. But then, if you look at the other part of the paragraph, they do mention legal obligations, and with the bit of background in international law of the sea, you know that these are, SAR law is not about creating jurisdictional powers, power conferring rules. It is about imposing primary obligations, an obligation to do something, to proceed to a scene, to start coordination, to cooperate, to make phone calls, to restrain from making bad decisions, and so on. And so what I found interesting and quite cool, the Human Rights Committee took this into account. And so really then, the question is like, okay, so can primary legal obligations under international law play a role where causation leads to discussions like, is it close enough, and so on, to be sort of an indicator of, yes, here, international law confirms that the state has obligations and it plays a role in triggering human rights jurisdiction. I think that if it was 7 minutes ago, I will have to go fast now. Inter-American Court is a fan of the factual elements in this causal model, but not so much of the role of primary rules. I found it surprising when I started with this idea, reading back into the case law of the European Court of Human Rights, that it seems to have been applying this for a while, even before the Human Rights Committee, in cases where arguably there is a lack of authority or control over the victim, and where, as a special feature, that's the latest kid on the block in the case law, it's becoming a huge bundle of possible things. Well, primary rules of international law of parties to the ECHR start playing a role where mere causation seems to be in doubt. So there's an example of obligations of a state under the European arrest warrant scheme. I will not go into detail. I guess these slides will be available. An obligation under a treaty, well, basically to keep someone in prison if you promise that you will do. And in Hanan, the fact that you have an obligation to investigate something under IHL. So it is there, but what is clear is it's only with regard to the procedural limb of the right to life, where if you compare it to the Human Rights Committee, it also used it for the substantive limb of the right to life. Has led to dissenting views. First of all, this first dissent was actually about the causal model altogether. Well, if you look at the Zimmerman dissenting opinion, he really spots, I think, there the fact that, hey, we're using primary rules of international law. What are you doing? And the same, more explicit in that sense, dissenting opinions in the Hanan case where they said, hey, if primary rules of international law become normatively relevant in triggering relations of duty for human rights purposes, where does this end? So there's definitely critique. And so to sum up, I know I rushed a bit. So causal powers are developing as a trigger of human rights jurisdiction. They remain contested in general. It seems that there might be a role in delineating in which situations you can embrace the model or not, that primary rules of international law can play a role. You see little pebbles in the water of the case law. I would say let's not reject it immediately, because in theory, or not in theory, like the EU, it draws on and enforces already existing obligations that states accepted. As if you come saying, hey, this expensive model starts expanding obligations of states, it will scare states away from human rights, from commitments. In a way, it's like, yes, if there's no legal qualification when it comes to the causal model, but here we're connecting it to something you already accepted. So far, always, this role of primary rules is still combined with other elements, so convincing factual elements predominantly, and yeah, so far limited to procedural limb of the human rights, at least in the case law of the ECHR, but potentially also for substantive limbs of human rights obligations. This will lead to probably, maybe after today, you will find yourself in the camp or somewhere in the middle, seeing this as this causal model and the role primary rules can play as a necessary correction and evolution of the human rights concept. Maybe this is stretching it too far. At least it can lead to discussions about, first of all, what kind of theory, political theory, moral theory of human rights can possibly accommodate for the causal powers model in general. If we involve primary rules of international law, do those rules, the content, have to fulfill certain conditions with direct effect, for instance? You could have a criterion of the primary rule itself is sufficiently clear and unconditional. Is that something we want to think about when we look at it? Does it matter from which regime you pull those primary rules? There might be differences. It's not because now in the law of the sea it seems to make sense that it makes sense for other regimes. And in the end, also, what will be the effect on the types of obligations that can be triggered as a result versus negative, positive, procedural versus substantive. And that was it. Thank you. I'm sorry.
Thank you very much, Dr. Gombert, for another very rich presentation, and also for offering an avenue which can be explored to limit the otherwise rather boundless effects or causal threshold theory, which may then lead to what has been expressed as a concern by Professor Ingart this morning, that we could maybe lose state support. So it's the line must somewhere be drawn. This presentation certainly provoked some questions, and I suggest that we collect 4 or 5 questions and we then do one big answer round, and then there will be maybe room for a final statement for each of the presenters. Who would like to take the floor? Richard Barnes, and then we have another question in the third round. Professor Ingart, another question. So we have at least 4 questions.
Okay, first let me thank the panelists for some tremendously interesting and insightful presentations, so thank you. Marco, you kind of put the heretical position there for the law of the sea, and I suppose my response would be equally heretical and say, as a law of the sea person, I probably agree with pretty much most of what you said. So I guess the point I probably want to make, though, and I think this came out during the panel presentations, is that the kind of core proposition you make is fine, but you just then need to nuance it. And I think the kind of point about the Human Rights Committee combining factual and legal elements kind of goes some way to kind of qualify your kind of more absolutist position. Either that or the Human Rights Committee is just simply wrong in terms of it kind of how it drew upon the kind of legal relationships. So I'd invite maybe the comment of the panel on that. I guess in some ways where the law of the sea scenarios we're talking about are different is because two things. First is that in all of the scenarios you talked about, it's the state which triggers jurisdiction by its acts. And I guess the challenge is, at sea, what we're seeing here is less so the state triggering human rights obligations, but it's actually the victims of human rights issues triggering the responsibility of states. So they can put themselves into the orbit of states' factual control or factual legal control. So that's maybe a slight difference there, I think. And then the other one is the kind of consequentialist argument. And this is the idea, and I think Christoph sort of touched upon this, is that when we apply the human rights norms, we have to be sensitive to the consequences that they have for legal obligations. And so we have an obligation to conduct search and rescue, and it's caveated and it's qualified, but as a result of the human rights triggering, it then will dissuade states from giving effect to that. I mean, I don't think that's a contradiction to your argument, but it's a kind of call to be sensitive, I think, to the context within which these legal, or which these operations arise. Thank you.
Thank you very much for your very interesting presentations. I would like to hear the views of the panel on one specific issue. Do you think that the assumption of responsibility by state basically over a search and rescue area places persons in distress under the jurisdiction of that state under human rights law? Thank you very much.
Thanks a lot for all the presentations. Just, Marco, to get this clear, and I think that was also a question that was posed by Leah, are you now against jurisdiction simply based on capability? So what is your actual view on AAS? Do you believe it was wrongly decided? Would you side, for instance, with the dissent by Yuval Shani, Heinz and Pazartzis? Is that the line that you would be following? And then about SS, I still wonder, should there be jurisdiction? You sort of implied, yes, there should be jurisdiction. It looks like a bit of intelligence sharing, although it's a bit more complicated, right? It's about capacity building. It's about externalization of migration control. So jurisdiction could become really unwieldy here. So I wonder about your position there. Violetta, you have a great piece forthcoming in the Netherlands International Law Review, obviously. Now, SS and AS are different, but they're both based on functional and contactless control or jurisdiction. So would you then share Marco's concerns about AS? First, Marco, of course, has to answer that question. We'll see where it lands. So could you react to that, perhaps? And if so, how is S conceptually different from AS, if at all? So these are my questions, a link between both cases, because the same model seems to be used there. Thank you.
We have one more question.
Yes, well, thank you very much to all panelists. Actually, Cedric stole my question, because I had the very same question to Marco. And just to add on that, because you hinted at some point, I think at the very beginning, you said something like probably positive obligations only apply into territorial context when there is a territorial control there. And I imagine also taking it from what you have extensively written about, that you're also thinking about situations of occupations and territorial occupations. But then, of course, my question would be, well, the law of the sea context offer some factual elements to think about it, because if we think about effective territorial control in the sea, it's very rare in a situation of effective territorial control. And that's my question. So do you think that what would be the normative principle underlying the applications of positive obligations in that context. So like the principle that would trigger the applicability of facts. And also because I think that at the very end you reduce everything to a question of attribution of conduct, in the sense that if we attribute conduct to the state, there is no problem of jurisdiction there. And so all negative, because also the distinctions, to me, the distinctions between negative obligations and positive obligations of human rights at the very end is also due and triggered by attribution of conduct. If attribution of conduct is the first step that you do in order to determine whether there is conduct of the state over there. And therefore, I see a huge a huge gap in the sense that once you attribute conduct, then you would have no problem of attributions, lots of scenarios in which should apply, et cetera, whereas in the cases where you don't have attribution of conduct, and therefore the questions ends up being when do you have attribution of conduct, then you would have a very little, if the assumptions is that positive obligations apply when there is effective territorial control, very little scenarios in which they should apply. I don't know if my question was clear enough. And then I had a question, or
can you be very brief? Otherwise, we will run out of time.
Yeah. I'll be very short. To Christoph. So when you mention that primary rules taken from other contexts may inform the applications of jurisdictions in international human rights law, also reading the essay and others versus Italy, I was wondering whether there is not really a matter of primary rules triggering the applications of jurisdictions, but is more a matter of interpreting those primary rules taken from other contexts, especially when they are positive obligations, as implying also some human rights, let's say, elements. So like human rights informing the interpretation on this primary rule and on the other way, and not the other way around. Thank you, sorry for taking.
And then the very final question.
Thank you. Very briefly, just to bring another scenario, I think everybody has been thinking about people drowning at sea, but, and of course, positive obligations are the hard ones. I will bring another scenario. There is a fishing vessel flying the flag of Korea, licensed by Italy to fish in the future Italian exclusive economic zone. And there is forced labor of Indonesian people taking place on board. So the vessel is under the Korean flag, the people are Indonesian, it's fishing in the exclusive economic zone, which is not territory of Italy. So Marco, but also everybody else, no one has jurisdiction. So no one has the obligation to protect the human rights. Because if we take jurisdiction to be only territorial, or to be only triggered when actually the state does something, these situations fall entirely outside jurisdiction, and so they fall entirely outside any protection of human rights. So how do we solve these type of situations? Thank you very much, and I think Violetta also.
Thank you. So I suggest that Violetta can go first. She's online. If you can be rather brief in your answers, as we have only roughly 10 minutes left for answering these many questions. Thank you.
Sound, microphone.
Okay, there is a technical issue, so I would, maybe Marco, you can go first, and then we will figure out what's not working meanwhile.
I'm happy to be Violetta's backup. So quite a few questions. So let me try to deal with them quickly. Alicia, let me start with your question. So first, about the relationship between jurisdiction and attribution. Let's just be clear. So for there to be a violation of human rights, there needs to be conduct that is attributable to the state, that's one condition, that violates the state's duties. This jurisdiction issue is not about attribution, it's about the existence of the obligation, right? It is true, however, that in my view, when it comes to negative duties, there is always going to be an existence of an obligation when the state acts. So again, if I'm a Serbian state agent and I kill Anna, right, Serbia will have the obligation not to kill Anna. That's what it is. That's all it means. The killing is attributable to Serbia. It's a violation of the right to life. There was no excuse to kill Anna. That's all it means. Just like on the territory of Serbia itself, right? Now, the issue with positive obligations is that the conduct being attributed is one of omission, failure to act. And then the state is responsible only if there's a duty to act. So again, I just, to be very simple about this, let's just think of one hypothetical. There's a lot of food in this country. Lots of food that Italian people don't need. Does Italy have a duty to send food to Ethiopia? There is famine now in Ethiopia. You could send food to Ethiopia. You're not doing it for various reasons. Do you have a duty to do it? That's the question. That's the difficult question. And I'm not sure that we have an answer to that question, right, after the whole panel. My answer in my book, I'm going to be very, very frank, is that I thought it was very unrealistic to expect states to agree to this duty as a matter of human rights law. That they will say, yes, when we signed up to human rights treaties, we agreed to provide food and water and medicine and everything else to all other countries in the world, which is why my argument was positive obligations confined to the state's own territory. That does mean, however, that lots of people fall through the gaps, and Irini, you pointed to one such example. In the example you gave, Italy would not have a duty. It's in Italy's EZ, but it's not in Italy's territory. It's a Korean ship, but Korea's half the world away. What can Korea do? And we can have numerous such examples with trafficking, with I don't know what, where you have that kind of gap issue, right? Richard, so a lot of the questions dealt with AS. If you look at the AS case, there are, Zimmerman is sort of advocating the kind of argument I had in my book, and he adds to that precisely the concern that if we want special solutions to special problems posed by the sea, it's the special rules that apply to the sea, like SAR, SOLAS, whatever, that should provide answers, not human rights law. And I have a lot of sympathy for that position. The problem, though, is states are not going to adapt special rules most of the time. You know, they're not going to be agile enough to fix problems through special rules. So that's you know, I have a lot of sympathy for Zimmerman's position. One thing that I find very interesting is how everybody in that case, in the majority, in the minority, is drawing some arbitrary line. Yeah? So Yuval Shani, who advocated for this functional model in his scholarship, who was the main author of General Comment 36 that said states have a duty to protect the right to life when they basically have the ability to do so, he was not comfortable with saying simply by being proximate, you have a duty to save drowning migrants, because he thought it would go too far. Yeah, and that's, I think, the big concern here. It's a utopia apology dynamic of the kind that Cedric had mentioned. I don't think the normative elements they mention make sense. So they say in the case, for example, Italy answered the distress call. Seriously, so you think if Italy ignored the distress call, somehow that would mean there was no obligation. So answering the distress call means you have more obligations than just ignoring this altogether. That can't be right, et cetera, right? So that's I think I'm going to finish here. Sorry if I failed to answer something.
Thank you. We'll have another try whether we can hear Violetta.
Thank you. Can you hear me?
Now it works.
Oh, okay, great. I'll try to be very brief and complementary to what has already been said. In terms of the point of victims triggering obligations rather than states triggering obligations, I really think it depends on the perspective one adopts. Because as I see it, the state that strategically retreats jurisdiction or engineers its incapacity to exercise control, it's what triggers the obligation in the first place. I mean, so victims that come within the SAR zone of Italy or Malta, at the bottom of it, they end up in that position because at the first, in the first place, Italy stopped the Mare Nostrum operation, for example, and it's not together with the other coastal states of the European Union, not really fulfilling, this is the view of many, their obligations under the SAR and SOLAS conventions and Article 98 of UNCLOS, in the sense that states have to provide rescue services that search for people and rescue them whenever possible, right? So I don't know if we can place the debate in terms of victims triggering obligations on purpose, because this can be reversed, right, in the way that I've explained. Then does control over a SAR zone places the individual within jurisdiction? And I suppose this comes back to the debate about positive obligations, which can, come down to believing or not believing on the capacity-based approach to jurisdiction. And here I think that I agree with Christoph that there can be input coming from the primary rules of other regimes, in the sense that we do know that under international human rights law, there is a positive duty to protect the right to life. And this becomes specified in the SAR and SOLAS conventions to the extent that in the SAR and SOLAS conventions, the formulation goes that there is a requirement on the part of the state to ask the master of a ship at sea, which is in a position to be able to provide assistance, and I'm literally reading from the convention, to proceed with all speeds to their assistant. So being in a position to offer help is actually determinant to the triggering of the obligation in the first place. So I do agree with Leah that in general terms, this capacity-based analysis would normally go to the determination of the content of the obligation rather than the jurisdictional test. But under the law of the sea as formulated, the two things collapse. And I don't see any other way in which positive obligations in extraterritorial settings could ever become meaningful in any other way. So here we have, and it comes to the scenario that Irene was presenting to us. So are omissions always off the hook if we're not clear about what positive obligations exist or do not exist in the first place? And to me, it is relevant that the failure to act has been defined in positive law somewhere as being constitutive of responsibility, right? And we also see that, again, in UNCLOS, Article 98 establishes again that every state shall require the master of a ship flying its flag insofar as he can do without serious danger to proceed with all possible speeds to the rescue of persons in distress. So this capacitous approach to the determination of whether there is or there isn't an obligation, positive obligation in this sense, it's already inscribed in the law and is a translation of moral duties that already exist and that customary international rules have for a long time recognized to exist. So I would be curious to learn what Leah thinks. I mean, when would the capacity-based approach ever be meaningful in this analysis? I mean, is it any scenario in which positive obligations can be triggered extraterritorially? Because if not, then SA was wrong and probably SS will also fail. Although, I'm coming to Cedric's question here, and with this I close, the two cases can be distinguished in the sense that in SS, what is predominant is a delegation on the part of Italy to the Libyan Coast Guard to execute actions that, if executed directly by Italy, would be illegal because we would be in a Hirsi scenario kind of situation, versus SA, which I think entails predominantly a series of strategic omissions that have been defined as such in pre-existing legal obligations defined in the law of the sea as positive duties on both Malta and Italy to act. One being the search and rescue zone state, Malta, and the other due to the capacity that it held in the factual scenario, engaging its responsibility under the SAR and SOLAS conventions. Thank you. I'll end there.
Thank you very much, Violetta. Then I give the floor to Christoph.
Yes, I'll pick a few questions. I think whether SAR zone triggers human rights jurisdiction, it depends on the paradigm you accept. Under authority paradigm, no. Under the control paradigm, no. Under the causal paradigm, yes, on the condition that you can show that based on legal elements, someone has a specific duty for that area compared to others. It doesn't tell you that. That's another thing, maybe potential for misunderstanding. Just the fact that Italy would be a duty bearer under this causal model does not mean that if it doesn't do certain things, like manages to rescue the people, that can still be fine under human rights law, because that's, I think, it's at a level of obligations where capacity comes in. If in that moment all 17 available vessels are gone at sea already, if the phone has been ringing the whole time, but just it's the status of being the MRCC point in a very narrow sense that has a potentially under that model a triggering role there. But I would limit to that. To Alice's question, yes, I agree. When you actually indeed move from the jurisdiction test to looking into the obligations, those very same primary obligations will start informing what a state should have been doing. So there's going to be a lot of interaction in both at the stage of triggering jurisdiction and in the stage of assessing the content of the obligations. That might lead to a problem that is mentioned this morning, one of the questions from the audience. Yeah, what if ECHR judges don't have law of the sea expertise and they have to apply SAR rules and so on in a human rights case? On the other hand, there will be other types of interaction, namely human rights can start becoming, at least in theory then, a means to enforce primary rules of international law, where maybe sometimes there's no possibility for it because of the national law of the state concerned. There are very strict conditions for direct effect. So lots of possible interactions. And then the EEZ vessel, I thought about what if you compare it to what we talked about earlier. Let's say a foreign vessel passing through the territorial sea on innocent passage. There are remarks made that, are human rights internal to the vessel? And if you accept that they are not, because you have sovereign rights in the territorial sea, I would say under jurisdiction, you have a right to do something. Under human rights obligations, I think you can make the argument that you have to. If you compare it then back to the EEZ, it depends if that vessel is there because it is allowed under the EEZ regime and rules of Italy to be there because of fishing. Italy, for the purposes of that relationship with that ship, has, in a way, sovereign rights, functionally limited, but therefore you can maybe start making in your head the parallel with the territorial sea scenario, where earlier today we thought maybe it is not purely internal, but that's I'll stop there. Not just a thought.
Thank you very much, and then you have the final word.
Thank you for your questions and the last word. The search and rescue zone question and jurisdiction in international human rights law, as soon as you have relevant knowledge, there are several things that come together. Capacity, arguably the control over the source of harm is here not the source of harm, but if you are going to draw lines in the sea like this, and then it has no consequences, I'm not sure why you would do it, right? So my intuition would be yes, it could go to capacity to control over the source of harm, and in any event could actually also be accommodated under the jurisdiction as political power account, although I would have to go back and read that chapter in my book again. Sorry about that. Irini, your scenario, same again. You can make lots of different arguments: political power, capacity, source of harm. The fact that nobody is responsible is a direct consequence of the regulatory framework. We've regulated ourselves into oblivion here, right? Fine. So in the end, you could make the argument that because of that, and because all are complicit in this, everyone's responsible. Everyone has jurisdiction. Now, The question, though, that you then need to ask, I think you can make these arguments and you can remain principled. I think Christoph's contribution on primary rules and their role added a lot of meat to the bone here. But what you then have to ask is, just because international human rights law provides individuals standing in international law in the way that other regimes do not, is that a good enough reason to use it to fill gaps in other regimes like this? And I think a lot of the questions we have been dealing with today, including Violetta's one on the capacity and positive obligations one, are actually about that. We can remain principled. There are very, very elegant arguments available to make jurisdiction fit all sorts of scenarios, including very expansive ones, and still remain strong on the justification. But then you need to think about the institutional background and the institutional purpose and what it will do to the human rights systems in practice that are in place to protect human rights. You do not want to go and undermine them, because we need them for other things too, not just for extraterritoriality or the sea.
Thank you very much. Please join me in thanking all the panelists for a very rich discussion and for a lot of food of thought.
Just a small housekeeping note again, losing pieces. Now we have a break. It's a short break, 15 minutes break, but there is coffee and biscuits just outside, and everybody, including students, are invited to get a cup of coffee so as to carry on until the end of the day.
All right, good afternoon, everybody. Thank you very much for joining us for this last session. We are following a slightly different format this time, despite the fact that the table looks exactly the same as when you were last in this room. Please picture it as a round table, because we are going to have each of the speakers will only be presenting for about 5 minutes. So there'll be a chance for a conversation in between our speakers, and hopefully again with you all as well. So my name is Natalie Klein. I am a professor at UNSW Sydney, and it is a delight to be here. I do want you to know I just recently came from Sydney. This is when the jet lag is starting to kick in a little bit, but I'm very hopeful that the interventions of my colleagues here will keep me awake and alert for these purposes. And we've had a wonderful session so far in discussing jurisdiction at sea. And just to bring some of those points together so far, I think Irini really brought the key question to us all in talking about jurisdiction as a means to identify a state that has a duty to protect human rights at sea. And then when we heard from the other speakers, similarly Cedric Reingard brought us to the question of when do states owe obligations and what obligations towards individuals at sea. And then I think Richard Barnes took us a little further, because rather than just saying, well, what do we need to do, we posed the important question of why, and why do we give authority to particular actors, because we can't always understand or know where authority could or should lie. So we had a number of sort of provocative questions posed to us, and happily we've started hearing some answers to these questions in the other presentations. So Marco suggested to us that we were all getting caught up unnecessarily in this idea about human rights at sea, but really what we needed to remember is that the principles just need to be applied consistently. And it mostly, but not always, comes down to when a state exercises authority, control, power, and that causes harm, but acknowledges it can be tricky when we start thinking about complicity, and also what I think is very problematic when it comes to the oceans, and that is where states fail to act. So Violetta gave us some solutions around the idea of functional jurisdiction and suggested we focus on an exercise of state functions that's determinative of a course of events of events that are impacting rights. And then we also heard from Leah about several options around political powers, and I thought posing the interesting question about asking whether capacity could be a way of talking about a relationship that produces human rights obligations. And Christoph similarly gave us a lot of food for thought, and particularly around the option of whether causal powers can be a trigger. But bringing back to one of our earlier speakers, Sarah Seck focused our attention on relationships. And for me, for what I think is a very difficult question around the scenario Irini gave us of the fishers who were on a vessel subject to forced labor in a state's EEZ, and what state has an obligation to do something about those human rights violations. Sarah's talked about the importance of relationships and what's the nature of the relationships at issue, and I think importantly really gave us a reminder that we need to think about non-state actors and not just states having obligations as well. So now in this final panel, we are going to have a panoply of perspectives on these different questions that we are dealing with. So I will not do lengthy introductions, especially as our first speaker needs to leave quite promptly after his presentation. So let me hand over first of all to Professor Marco Boracetti, who is an Associate Professor of European Union Law for the Department of Political and Social Sciences at the University of Bologna. So I would welcome you to present your remarks. Thank you, Marco.
Thank you very much. 5 points, my fast presentation, quick presentation. First of all, I want to thank Irini for the organization and for having invited me to experience these 2 days, because yesterday I was giving classes here, and it was really a very nice experience. The second point, I want to give my apologies to all of you for 2 things. First of all, my boss, that is 3 years old, told me that I should be at home at tonight. So once I finish, I should really go to the airport, because tomorrow there is a strike. I cannot miss the last flight to Vienna. And the second, my apologies to all of you, because I'm not an international lawyer. I'm a European Union lawyer, so you saw that could be very different. The third point is about the focus on my quick presentation. And at the beginning, I want to speak about jurisdiction in case of trafficking human beings, and on a few words on the agreement between Italy and Albania. And then after the presentation we heard in the morning and the second one in the afternoon, I decided to switch just to the agreement between Italy and Albania, because I think it is a very important. And just to answer to the question, I don't know if we are going forward, passing backward as in rugby, but my impression is that we are going back. Why? Because I see several points where we are trying to let's say, working in a direction where there are less right guarantee. And this, in my opinion, is something going backward without going forward. I want to give you some examples. The agreement between Italy and Albania, I don't want to stress the possible conflict with the European Union law or with the Italian constitution, but there are some controversial points. First of all, it should apply just to people that are rescued at sea by the Italian Navy. These people should be put in detention for a time that is maximum a month until there is an answer by the Italian authorities. So I see some problem in the respect of what the European Union law at least is saying about access to legal counseling, access to legal representation, and also about health assistance, because we don't know if during the staying there they are guaranteed, even if the Italian government said that there will be agreement with the Albanian authorities. So the second point is, are we going to a situation where there is the Italian government is trying to deny the possibility to apply for asylum? Because according to the Italian government, the answer is no, but for sure there is the risk to have a different treatment between people in Albania and people in Italy. And anyway, they will need to change the legislation about the competent judge, the competent administration. And also, there will be a problem of access, meaning not just for the people there, but to monitor the situation there. So there will be an agreement between the Italian government and the Albanian government to guarantee free access for the member of the parliament and to the civil society that anyway will be put in different conditions than having someone in Italy. And then are we trying to see in a different way, a different model of asylum? Because according to if you see this type of agreement in connection with what the Popular Party just yesterday agree in this General Assembly they had where they decided the Spitzenkandidat will be the current president of the Commission, they took as an example the model of the agreement between UK and Rwanda. So more than a practical issue now, I invite you to consider the agreement with Italy-Albania as a precedent for the future. And I think that we are going in a direction where there is not per se the denial of protection, but the fact that the protection could happen somewhere else without taking into consideration, for example, the need to respect the principle of equivalent measure guaranteed by EU law for sure, and or the Convention of Human Rights. And the last point is about victims of trafficking. So the recognition of jurisdiction is also a matter of state responsibility on prevention, protection, and prosecution. Prosecution of a trafficker, prevention of the crime, and protection of the victims. How could we protect victims if the fast screening will happen in the ship of the Italian Navy and then in another place? I think that this could be put at risk again, the protection of vulnerable people on vulnerable position. So at the end, I see more than a risky situation in the practical situation and in the current moment. Again, I want to stress it, the idea to change, to have a new paradigm where we want to keep people abroad, but before we were not taking care of them. Now, because of the judgment of Court of Human Rights and the Court of Justice and the National Court, the idea is to keep them out, to support their system there, but without taking care of the real condition, and anyway, without respecting the principle of equivalence in their protection in the third country. Thank you for your attention.
All right, thanks very much, Marco. I think it is important for us to consider the value of precedents and thinking about the Italy and Albania example. Unfortunately, coming from Australia, there's no shortage of examples of setting bad precedents for the treatment of people arriving by sea, and I fear that Australia's bad practices have indeed set some examples for Europe, though Australia has the perhaps advantage/disadvantage of not being part of any regional human rights system, and so does not get reviewed in the same way. So that in itself, of course, makes the application of these human rights protections even more problematic. Let me now hand the mic to Dr. Francesca Di Vittor, who is a researcher and assistant professor in international law at the Faculty of Law at the Catholic University of Milan. Thank you.
Thank you. I thank really Irini to invite me. Irini asked me to give you the perspective of Italian national case law on jurisdiction. So I will just deal with the national case law and not with the international case law. And first of all, I need to say that looking at the case law of the Italian Supreme Court, what we can see is that mainly the Supreme Court does not choose any model on jurisdiction, just pick up phrases from different cases and put them together, quite often without taking even into account if the term jurisdiction is used in one field or the other. The Italian relevant case law on jurisdiction in the areas of the sea beyond national jurisdiction mainly concerns the exercise of criminal jurisdiction on the individual accused of trafficking or smuggling of migrants. Even though these cases show the tendency of the case law to extend national jurisdiction, meaning the applicability of criminal law and the competence of national judges beyond territorial sea or even contiguous zone, this practice, seems to me, does not directly and explicitly support the extension of the Italian jurisdiction in its meaning of exercise of sovereign powers and control over people to the ends of applicability of human rights treaties. Nevertheless, some quite relevant consideration on this last matter can be drawn from the recent judgment of the Supreme Court in the so-called ASSO 28 case. It's a judgment of a few weeks ago. Indeed, this judgment goes further the Hirsi-Yamaha judgment of the European Court of Human Rights, explicitly establishing that there is Italian jurisdiction under Article 1 of the Convention, whenever the shipmaster of a private Italian ship carries out search and rescue duties by embarking people, no matter if under the coordination of Italian MRCC or not. This conclusion is broadening the Hirsi-Yamaha in which people were on board an Italian state vessel, and the European Court of Human Rights considered both elements, jurisdiction of the flag state under the law of the sea, and the fact that in that particular case, the vessel was a state military one. Let's, just for whom do not know the case, just briefly remember the facts in ASSO 28 case. In 2018, ASSO 28, a supply vessel in service around the offshore oil plant Sabrata in the Mediterranean Sea near Libya, rescued about 100 migrants without contacting the MRCC Rome nor the MRCC from Tripoli. The shipmasters brought these people near Tripoli, where they were transferred to a Libyan Coast Guard vessel and then disembarked in Libya. Considering that Libya is not a place of safety, the shipmaster was sentenced by the Italian National Tribunal for the crimes of child abandonment and abandonment of rescued people. Confirming the sentence of the tribunal and of the Court of Appeal of Naples, the Court of Cassation affirmed that, I'm quoting, the master of the Italian civil ship is to be considered under Italian law for certain security police function, such as those pertaining to rescue at sea, as a public service appointee. Therefore, the master of the private ship also acts as an agent of the state in international water with regard to this function. Through the master of the ship, the state in fact, exercises control and authority over an individual and thus jurisdiction, and is bound by Article 1 of the European Convention of Human Rights to recognize to that individual the rights and freedoms set out in the first title of the Convention. So the master of the ship, even acting alone without any indication from the national authorities, engages the responsibility of the state concerning the protection of human rights recognized by the Convention. Further, the Court of Cassation considered that because the master did not contact any search and rescue coordination center, the responsibility to assess with due diligence the safety of the people of the place for the disembarkation was entirely on him. Indeed, in the court opinion, the entire course of the efforts shows malice in the conduct of the master. The consequence of this approach is manifestly that the coordination by an MRCC is relevant for the threshold of due diligence asked to the shipmaster under national criminal law, but not for the jurisdiction of the flag state. At least not when the coordinating MRCC and the flag state are the same. You have no answer for the other. This consideration brings me to the second case I'd like to mention. The Vostalassa case ended with the judgment of the Supreme Court in April 2002. In this case, the accused were the rescued migrants who violently opposed to the shipmaster when they understood he was bringing them back to Libya. The Court of Cassation confirmed the sentence of the tribunal, who had acquitted the accused migrants, considering that when opposing the master, they were acting in self-defense, preventing their illegitimate refoulement to Libya. In that same judgment, the tribunal considered that even though the refoulement to Libya was a wrongful act, the master had no violated his due diligence responsibility because he was following the instruction of the Libyan Coast Guard. So his conduct was justified. Still leaving open the question of the exercise of jurisdiction when coordinating unit is the Libyan Coast Guard, of course, it seems to me that the Vostalassa case confirms that in the case of coordination by an MRCC, we only have a shift on which state organ engage in due diligence, but not on state jurisdiction for the human rights responsibility. So, or is the shipmaster or is the MRCC, in any case, there is a state jurisdiction, at least in the case of Italian national courts. Final point must be raised, and is a practical one, in connection with this extension of applicability of human rights obligation by Italy as a flag state. In several cases, Italian courts have recognized a right to be provided with humanitarian visa to asylum seekers in Libya who are able to demonstrate a jurisdictional link with Italy. In one case, such visas have been provided to people pushed back to Libya in the Irsi event as a sort of reparation on the basis that Italy was responsible for their faith. Potentially, putting together the Cassation decision, the Supreme Court decision in ASO 28, and those decisions gives an access to humanitarian visas to Italy to all people eventually pushed back to Libya by a private vessel flying the Italian flag. That was all. Sorry for taking too much time.
Thank you very much. We were talking earlier today about the need for more case law, so it may be a little bit of careful what you wish for in that regard sometimes, but thank you. It was very interesting to hear about those decisions. Let me now turn to Dr. Sofia Galani, who is an assistant professor at the Pantheon University of Athens. Over to you, Sofia, please.
Thank you, Natalie. Well, first of all, huge thanks to Irini for gathering us all here. It's a great opportunity to discuss these very important issues. I had in mind something different from what I'm going to talk about, because by listening to other people today, I thought that it might worth, making an effort to engage with some of these issues and sharing some thoughts and, adding some things for further consideration. So I would like to share some thoughts about why I think that jurisdiction at sea is not that simple. And I very much like simplicity, and I really liked what Marcus said, and I wish things were simple, because this would make our lives much easier. But I think that jurisdiction at sea is equally complex within territorial waters, within the areas that states exercise sovereignty, and beyond. And we focused a lot on extraterritorial matters, but actually exercising jurisdiction for the purposes of protecting people at sea is equally complex within the areas that states exercise sovereignty and beyond. And I think that while we all agree that human rights apply at sea, as they do on land, there is a kind of a normative challenge there. And I think that we should not overlook Article 311 of UNCLOS. It's a very interesting provision that says that the Convention does not alter the obligations and the rights that states have under other treaties, and they can exercise these obligations and these rights as long as they do not affect the rights and obligations that states have under UNCLOS. My understanding is that if there is a conflict between UNCLOS and, let's say, human rights law, UNCLOS will take precedence. And this is where things become complicated. So if we consider different examples, and if we start from where states exercise sovereignty, in ports, for example, ports are internal waters, coastal states exercise sovereignty. They can prescribe human rights laws, they can enforce human rights laws. And then you have a foreign flagged vessel in your port. And you know that human rights violations take place on board. And we know that under the law of the sea, as a rule of comity, you don't intervene in the internal economy of the vessel. And I mean, a coastal state might say that, human rights violations disturb the security of the state, or they violate my laws, I'm going to do something about it. Yes and no, because this changes the law of the sea. And I'm not sure how willing states are to do that. And they might be willing to do that with respect to seafarers, for example, and they might enforce the laws in order to protect seafarers who are being abused. But I'm pretty sure that they wouldn't be doing the same if on board there were migrants. As long as you don't disembark them, take them away, I don't want to intervene. It doesn't affect my security, for example. The same happens with innocent passage, and I think Christoph mentioned this example earlier. A vessel merely navigates through your territorial sea. On board there are people, their human rights are being violated. Within your territorial sea, you can exercise sovereignty. You can prescribe laws, you can enforce human rights laws. But we know that innocent passage is a restriction of the sovereignty of coastal states, and this is something unique about the law of the sea. It doesn't happen in other cases on land, but it happens at sea. The right of innocent passage limits the sovereignty of a coastal state. And that means that a coastal state may exercise jurisdiction, but again, we don't know whether this will happen in practice, because it will affect the interpretation and application of the law of the sea. And again, there might be some special cases where you have torture or jus cogens violations, and states might be willing to exercise their jurisdiction, but you might again have migrants, and they merely navigate, and they're leaving your territorial waters, and you don't want to intervene. Or you might intervene, and the flag state might bring a case against you, and it might say you breached my right of innocent passage. It's a violation of international law. How are you going to justify that? Again, you might say it disturbs, the peace and security and good order of my territorial waters, but it's difficult to happen. And of course, the further away you move from the coast, the more complex things become. I mean, what happens if You have a vessel in your contiguous zone. Again, violations take place on board. There isn't much you can do. You're not allowed to do anything under the law of the sea. If that vessel comes to your territorial waters, things are different, but what if you think that it's an incoming vessel, but then it leaves your contiguous zone, it doesn't come to your territorial waters, and you exercise jurisdiction for the purposes of protecting human rights? I mean, even the International Court of Justice told us that Article 33 about the contiguous zone is very specific. You don't exercise any jurisdiction other than what the convention says about customs, immigration, health, and sanitary laws. So again, there isn't much you can do. And then again, on the high seas, you cannot override the exclusive jurisdiction of the flag state. You may be next to a vessel, and you know that on board that vessel, human rights violations occur. The convention does not allow you to board that vessel. The right of visit can be exercised in very specific situations, and human rights are not one of these. Now, someone would say, but, well, yes, this happens on land. You know, you have neighboring countries, they violate human rights, you know that. There isn't anything you can do about it. Why human rights at sea are different? But then it's also the practical issues here. I mean, if you're on land, you can call the police, as Irene said. You can call an NGO, you can call your lawyer, you can run away to escape the human rights violations. You cannot do these things at sea. So practically, things are different as well. And we should not overlook that high seas cover a very large part of our planet. So it's not that we're talking about a very small area. We're talking about a very large area where, you know, if human rights are not protected and the flag state doesn't do anything, there isn't much we can do. So I think these questions are difficult to answer. It's difficult to answer because of the limitations of UNCLOS, but it's also difficult to answer because of the lack of state practice. I mean, from my experience so far, I see that states assert jurisdiction on the basis of who they have to protect. They might be more willing to protect seafarers or passengers, but they're not willing to protect migrants. But if they keep behaving this way, it's very difficult to have custom or to have something that will help us interpret the law of the sea and human rights law. So these things are very different. I will stop here just to say that it's a very good opportunity for the ILA committee to consider some of these questions. But I mean, I'm here to discuss the way forward, but I haven't given you any answers, only problems. But I think that no matter what we decide and where we're willing to push for jurisdiction at sea, I think that we cannot do this at the expense of UNCLOS. And I think it's important to bear this in mind. Thank you.
Thank you very much, Sophia, and not to worry because the ILA committee is meeting tomorrow, so we've got all of tomorrow to come up with the solutions for all the different problems we are currently identifying. Let me now turn to Gabrielle Gurjewamli, who is the former director of the Division for Ocean Affairs and the Law of the Sea and now works as an independent international expert. So delighted to have you here with someone coming from a non-academic perspective on these questions. So over to you.
Okay. Well, first of all, good afternoon, participants, distinguished participants, and many thanks to Irene and other organizers who invited me to this very interesting conference. I'm learning a lot, and there's a lot to digest in what one has heard today. Let me just say that, no, I don't have any solutions either at this point, but I would like to just pick up on a couple of points that were made and maybe provide my thinking, initial thinking. Of course, I agree with what was said this morning. There's been very little interaction between the law of the sea and human rights. Over the years, and I should say, when we talk about the law of the sea, we can also maybe have a discussion, what are we intending to cover by that term, because there are different views. I'm looking at it very broadly. just to say. And of course, but there have been points of contact, and this is also visible, and my work experience has been very much been with policymakers, and the UN General Assembly resolutions on oceans and law of the sea, where the General Assembly tries to address most of the law of the sea issues, ocean issues. More and more paragraphs are being devoted to situations of human rights violations. No, they don't mention human rights per se as a word, but it's clear that they have picked up on the major issues, and so that's a good sign. And also the BBNJ agreement, okay, the agreement under the United Nations Convention under the Law of the Sea on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction includes some human rights norms and principles. And so these are very good developments, and it shows that the policymakers might be open also to considering certain issues. Let me just say migration is a problematic area. So much more needs to be done, and I will now probably push the ball into the Law of the Sea Court, because I think the ocean community has yet to embrace fully the full spectrum of human rights norms and obligations. So, and human rights should apply at sea as they do on land. Now, in some cases, it's a matter of political or other reasons why they don't take the necessary action. But there's also, I would put forward, that there's also a lack of awareness in some cases of the full spectrum and how these regimes interact. Fragmentation in ocean governance is a huge problem in the ocean. So I actually embraced very much and we've had this discussion this afternoon, the Human Rights Committee, the UN Human Rights Committee, which invoked law of the sea obligations in order to, and as well as factual elements, of course, in order to establish jurisdiction, which otherwise wouldn't have been present. It's very important also to fortify the law of the sea obligations. I saw that also as a way of holding states accountable, which is not, there is no mechanism unless you go to the tribunals to do that. The readiness to consider other branches of international law, I think, is also interesting, and particularly now turning to environmental law, where I expect there'll be a huge caseload in the future. The Human Rights Committee's comment that the obligations of states under international environmental law should inform the content of Article 6 of the International Covenant of Civil and Political Rights. That's a very good way forward. And there's, of course, now also an international human right for a safe and a clean, healthy, and sustainable environment. So it'll be interesting to see how that will be implemented. In their amicus brief submitted to the International Tribunal for the Law of the Sea in relation to case number 31, which is an advisory opinion submitted by the Commission of Small Island States on Climate Change and International Law, the UN Special Rapporteurs that deal with human rights and climate change, toxins and human rights and the environment indicated, for example, and here I quote, that the adverse impacts of the climate crisis on fishing communities, and in particular communities with traditional and customary fishing rights, may amount to a violation of obligations under both the UN Convention on the Law of the Sea and international human rights law. And we see the impact of climate change already, and it's what it's doing. So the UN rapporteurs also stated that to address marine pollution and the climate emergency, the norms and obligations established in UNCLOS, human rights law, and international environmental law must be applied using an approach of systemic interpretation. Of course, an approach of a systemic interpretation is also needed, I would posit, on situations where there are other relevant areas of international law that are involved, for example, labor law, maritime law, etc. So how can this be facilitated? Because I'm a supporter of trying to bring these regimes together. I think they can complement each other. I don't see them as isolationists. So moving forward, I think we need to take a whole of law and a whole of sector approach. I'm sure this doesn't exist in any academic world writings, but looking, and particularly not just what is happening in the Human Rights Committee, but also looking at what are the what's happening in the in IMO, in the International Labour Organization, for example, and also seeing what are the opportunities there. So as a first step, well, we need a comprehensive assessment of what protection issues might arise with respect to various activities that are undertaken by people at sea and may require the exercise of jurisdiction. And of course, the different types of jurisdiction would also need to be identified. But I won't go any further because this is all part of what the committee, the ILA committee has on its plate. And so maybe I'll just leave it at there. I think my 5 minutes are probably up. But I also want to just emphasize one point. We need to look at also what the gaps are. The example that Irini cited in relation to forced labor is one that is extremely striking. Thank you.
Thanks very much, Gabrielle. And I do think it is important for us not to lose sight of the work of different intergovernmental organizations and what they could potentially contribute. And contribute both in terms of perpetuating problems as well as contribute to solving those problems. So thinking of the siloing that happens around the work of the IMO, the ILO, and also the Food and Agricultural Organization, which should be dealing with some of these fisheries issues, but tends not to happen. All right, so let's move on to Pierandrea Lucci, who will also be bringing us more of a perspective from outside of academia as he works as a legal officer and control assistant at the Fisheries Control and Inspections Unit of the Directorate General for Maritime Affairs and Fisheries of the European Commission. So perhaps an opening to explain what the European Commission is doing where the FAO is not, but not to prejudge your remarks in any way. So over to you. Thank you, Pierandrea.
Thank you very much, and good afternoon, everyone. And thank you to Irini and colleagues also for organizing this wonderfully crafted event and tough provoking. What I would like to discuss with you today, and just to give, okay, let's start maybe with some data, which put everything also in perspective and which touches upon two other aspects which were mentioned, and then including the examples, for instance, of Irini, and something that Professor Barnes mentioned this morning concerning also the possibility of addressing some human rights issues in the fisheries field. Now, according to data from UNODC of last year, there are around 27 million people in the world that are trafficked to be forced into work. Of these 27 million, the 29% are forced to work in the fishing industry. Now, we are not talking only about people working, of course, on fishing vessels, but this is an important, let's say, amount of people. And at the same time, this is not something which concerns only the other side of the world. I mean, this is something happening in our backyard. There was a very interesting report published last year, if I'm not mistaken, by the University of Nottingham, for instance, which addressed the issue in the UK, for instance, of forced labor on board the fishing vessels. Now, why I'm starting from here? Because as you see, forced labor is connected with human trafficking, is connected with migration, is connected with climate change. If you look at the IPCC report, the Intergovernmental Panel Climate Change Report, the last one, you will find at least 2 paragraphs dealing with the position of migrant workers exploited on board fishing vessels. Because climate change, as Gabi mentioned, it create and emphasize, intensify this vulnerability, okay? Now, why I'm saying that, and this is important in the context also of the work that the European Union has been doing recently, especially with an important reform, legislative reform, is the reform of the fisheries control system. Which, I mean, this is part of the common fisheries policy. For those of you who are not familiar, this is is an exclusive competence of the Union, which means it's very important. I mean, because the European Union can represent directly also a member state and has more power in that respect also from a legislative standpoint. But at the same time, it's something dealing with conservation and management. So sometimes there is a common mistake, you know, that since we are dealing with conservation and management, it has nothing to do with human rights, which is not the case, absolutely. And I can prove you with this specific example. I mean, in 2018, the Commission tabled a very important legislative proposal to reform the entire fisheries control system. What is fisheries control? It's one of the pillars of the CFP because it's the one which is set out to ensure compliance with the rules. So it includes, for instance, rules on enforcement, on sanctioning, and the centerpiece of this system in particular is the control regulation. Now, the control regulation includes, and this is a list, and this list is complemented by another important piece of EU legislation, which is the IUU regulation. It includes a list of serious violations of the CFP, which is very serious fishery offense. Now, this list, which is drawn upon in a certain way in Article 21 of the Fish Stock Agreement, but then it was expanded, and in any case, it has a broader scope. But this list now, under the new reform, includes a very important new serious offense, which is fishing activities conducted with the use of forced labor. Now, this new serious offense was included in the context of the reform during trilogue negotiations. So this was not part of the initial legislative proposal of the Commission, which also gives you an idea how it's important, working inside these negotiations, the impact that you could have inside these negotiations also. And why this is important? Because from now on, I mean, these rules entered into force on 9 January 2024, so very recently, but they will apply in 2 years, so 9 January 2026. So thanks to these rules, there will be the obligation of fishery inspectors to, based on certain inspection benchmark, to stop vessels, inspect vessels, and when they suspect, not even confirm, suspect that there might be fishing activities conducted with the use of forced labor, and by the way, I'm not saying forced labor per se, because in that case it would be covered by different jurisdictions and different authorities. When there are fishing activities conducted with the use of forced labor, they have the obligation to redirect the vessel into port, conduct further investigation, and inform the competent authorities. You can say that this is really a breakthrough in terms of protections and promotions of human rights, because we crack this enforcement dilemma we were discussing before. Because now every time that there is a foreign vessel in Union waters, there is the obligation, the possibility of exercise, first and foremost, enforcement jurisdiction, based on the exclusive coastal state jurisdiction in fisheries. And then at the same time, the fisheries authorities will be responsible for conducting also a preliminary assessment. And I'm saying this is very important because according to UNODC report already 10 years ago, what the UNODC said is that fishery inspector, and I can confirm that, having discussed this topic many times with them, believe that human rights is something falling outside their remit. So even they are the first one and sometimes the only one going on board the fishing vessels, but the problem is that they believe that anything dealing with human rights is not something that involves their job, which means, and I quote the UNODC, that human rights violations are not identified, are not reported, and are not punished. So in this way, there will be the obligations for the inspectors of doing so, and we, of course, as Commission, we will help them to develop the necessary also guidance. So just to conclude, in terms, since we are discussing the way forward, I think this is a very important way forward. The internalization of human rights considerations into the fisheries legislation can really be something important to protect and promote human rights. Thank you.
Great, thank you very much. I'm going to quickly abuse my position as chair. Can I clarify, so that regulation will apply within the coastal waters of all EU states. It applies to EU vessels when they are fishing in the South China Sea, for example, and they are inspected in port. So I just wanted to get a clear sense of the scope of application.
I'm struggling. Okay, I'm struggling with the microphone. It will apply to all fishing vessels in union waters, so local, let's say, union and the foreign fishing vessels, and to a union fishing vessel outside union waters, so even when they operate outside union waters, yes.
Thank you. That does sound very promising indeed. So it's nice to have a good news story for once today. And I'm sure continuing in that vein, no doubt, is Professor Stephen Haynes, who perhaps we can say straddles both the academy and the practicing side, being a professor of public international law at the University of Greenwich, but also formerly an officer in the Royal Navy, and also here in his capacity as a trustee for the NGO of Human Rights at Sea. So over to you, Stephen.
Thanks very much indeed, Natalie, and a tremendous thanks to Irini and the team for putting this session together, and indeed the committee meeting that we've got tomorrow. I'm actually a bit of a fraud, to be honest. I mean, I've been sitting in the audience listening to the presentations today, and it convinces me, if I didn't need convincing, and I certainly didn't, that I'm not really an international lawyer in the way that most people are. I came to the law from a practical policy experience and also from an academic background in international politics rather than through the legal process. So, and fundamentally, I'm a simple sailor. That was my first 30-year plus profession. And as such, I'm very interested indeed in the practical end of this particular debate. And I mentioned this morning that there are a number of serious problems, but I'm also conscious that we're talking about the way forward in this round table. The problems are immense. I'll give you a bit of a story. Just a few years ago, I was at a conference in London, and one of the presenters was somebody who went on to become our first Sea Lord, the head of our Navy. He was an officer that I knew, and at the time that he was speaking, he was the Commander-in-Chief of our fleet. And at the time, he was going on and making a big thing about the fact that the Royal Navy had been instrumental in stopping the North Atlantic slave trade in the 19th century. Well, I asked him afterwards, over a cup of coffee, what he, as the Commander-in-Chief of that self-same Navy, was doing to stop slavery at sea in the Atlantic in the 21st century. Well, he made his excuses and said that he had to go and speak to somebody else. The fact is, and the point that really makes me very frustrated, is that there isn't a single state anywhere on the planet that is committed to enforcing human rights law at sea. Not one. Not only is there not one willing to do it, I would argue that there is not one with the capacity to do it. So whilst it's fascinating and clearly very important that we discuss the sort of legal jurisprudential issues to do with jurisdiction at sea and the processes in case law and so on and so forth, my focus, because of my background, has been on how this is enforced at sea. What can we do, possibly, to ensure that this situation at sea comes to an end? Now, Irini very kindly mentioned earlier on this morning that I'd done some calculations. My calculations as a background to my work on human rights at sea with the NGO was that there are approximately 30 million people, men, women, and children, at sea as I am speaking this afternoon. 30 million people physically at sea, most of whom are fishers. Now, that's the population of a medium-sized state. Whenever I ask people how many people they think they're at sea at any one time, they usually say about 1 million or 2 million or 3 million. No, there are getting on for 30 million. And they are operating, living, working, traveling in what is, to a very large extent, a human rights vacuum. Nobody is enforcing human rights in terms of their presence at sea. And that really must stop. Now, I've got a problem with this because I don't see an easy solution. I'm a great fan of Grotius and was for many years a great fan of the idea of mare liberum. I am no longer. And indeed, Grotius, and I'm very, very conscious of Hersch Lauterpacht's very interesting essay on Grotius and the approach to international law. Grotius is known these days by international relations scholars as a rationalist. I do not believe he would come up with mare liberum if he was looking at the problems that we're facing today. There has been a massive shift in the last 50, 60, 70 years since the middle of the 20th century. What can we possibly do? Well, here I'm going to do a bit of advertising, if you like, for one thing that Irini, Anna Petrig, Sofia Galani, I'm glad we're all here together in Milan this afternoon. We worked together to produce something called the Geneva Declaration on Human Rights at Sea. It's a very small move, but there is in that Geneva Declaration an annex, which is the operationalizing annex. It's a soft law instrument. We list port state, coastal state, flag state responsibilities in various zones of jurisdiction and on the high seas. We make suggestions based on the law, but we also make suggestions that are basically ideas that states may care to take up in order to enhance human rights compliance at sea. It's a very small step. I don't expect to see human rights effectively complied with and enforced at sea in my lifetime. I'm too old for that. Maybe one or two people in the audience will see it, but I certainly won't. But we have to start somewhere. And we're trying this year to get the Geneva Declaration on Human Rights at Sea accepted by 1 or 2 states. That is my objective this year. I'm not massively optimistic, but I'm going to see what I can do, and we're going to see what we can achieve with that. I need states' endorsement and involvement in this in order to get access to the UN human rights bodies, to the General Assembly, to the IMO, to the FAO. These are all organizations that need to be engaged with, and this is an instrument that we're hoping will be a part of that process. As a way forward, that's my suggestion. I'll bring that to the table tomorrow as well. But it's a very, very difficult problem. I said it was the elephant in the room this morning, and I meant it. We can talk all we like about the finer points of jurisdiction and jurisprudence, but if we cannot enforce it at sea, because there are no states willing to do so, we do have a major problem. Thank you.
Great, thank you very much, Stephen. And the Geneva Declaration on Human Rights at Sea was mentioned earlier, and also the comment that if you haven't seen it, you can find it very easily online if you want to have a look, and particularly at the annex that deals with these questions. So thank you so much to all the panelists, and especially for keeping very closely within the time frame that we have. So this does give us time to open the floor for discussion. And as a first step, I would actually, since we're in metaphorical round table, I would open the floor if any of the panelists wanted to comment or ask questions of each other based on the presentations that you've seen in first instance, and then happily turn to the floor otherwise or in addition, and only just ask that, given we've had fairly short presentations, that any comments or questions could equally be precise and to the point, so we can canvass a range of issues. Did any of the speakers? Gabrielle? Yep.
Perhaps I can make one comment, and that was Pierre-Andrea mentioning this new EU development relating to fisheries and international human rights law. I must thank very much Irini, because I remember at a session in Malta 2 or 3 years ago, before the pandemic, we were talking about this very problem. And I was a former British Sea Fisheries officer, incidentally. I said, you can't possibly enforce human rights law as part of the fisheries jurisdiction. And Irini challenged me and said, this is simply not true because, of course, you issue licenses to fish in an exclusive economic zone. You can make a condition of that license being compliance with human rights law. So spot on, Irini was pointing this out some time ago, and I'm absolutely delighted that the EU is adopting this approach. It's in the Geneva Declaration on Human Rights at Sea, incidentally, so I'm glad that the EU is following our lead. Thank you.
Thank you. Gabrielle, did you?
Well, it was actually also following up on that and more specifically, well, we still, I think, have the problem, even though this is great news from the EU, but we still have a problem that in many cases the forced labor situation, there are no ships coming to port. These people stay out at sea. The fish, the catch is being transshipped, and the people just stay out there. So who is going to help them? Who has jurisdiction? Who has the willingness to even take any action? And how we're going to monitor? And starting now with the monitoring, and we forget the flag state because in many cases these same vessels are also engaged in illegal, unregulated, unreported fishing. So they are not, they're probably flying. If they're flying a flag, they're flying a flag of convenience, even though. So how do we address that? And that is, I think, one of the huge problems here. You know, and who would have responsibility if it's not the flag state? Do you have an international watchdog who uses space technology to see what is going on? Because that seems to be the only option, unless you have a group of willing states, and I take the point there aren't many out there that are saying that we're going to go and police the world seas and enforce human rights. This is not happening. So, of course, there are also things that we could consider perhaps trade measures. Trade measures or certification. We already have certification, you know, sustainable fish. So why not add also the labor, decent labor conditions? But that's just a thought. Thank you.
Thank you. No, just to comment on what Gabby just said, I think it's a very, very important aspect. And I mean, two comments, two remarks, let's say, from my side. The first one, this is the reason why I think also when it comes to implementing the union legislation, it's very important to have states on board, in the sense that states and the national authorities also to be well prepared. And this is also the reason why, for instance, we have these 2 years, let's say, you know, preparatory sort of phase-in approach. And this works especially through the risk management, which is, of course, as someone mentioned it this morning, it's unrealistic to think that, I mean, states could know what happened on board all their vessels. And if I'm not mistaken, this is also one of the passages in the South China Sea that says it's impossible, I mean, to know what's happening on board all the vessels. But at least we can work on the risk management, so to establish certain standards, certain conditions, and benchmark for inspections, which help the national authority to determine, so to pre-identify certain categories of vessels, based, for instance, on the history of non-compliance of the vessels, or of the specific fleet segment, or the gears used, the areas where they fish. So on that part of the story, I think there is some work that can be done and also to facilitate, let's say, the identification of forced labor. And the other one, which is in a way connected, is the use of new technology, in my view. Recently, there was a study conducted by McDonald on 16,000 vessels. I know that there are some scientists who challenged it, but I mean, he focused on the use of AIS technology. So automatic identification system is not the only technology or tracking technology technology that we have. Recently, for instance, in some RFMOs, there is a growing use of, they call it digital observers, or the use of remote electronic monitoring with cameras on board. I mean, there are different technology which are emerging, and I think they could be very useful in monitoring, indeed, the activities of fishing vessels, and making, indeed, the work of the national authority easier, I think, in that respect.
Great, thank you. And also, actually, in following up on the EU's initiative and Gabrielle's comments around what else could be done, it's probably worth noting that there are regional fisheries management organizations that are actually looking at this at the moment, and currently the Western and Central Pacific Fisheries Commission is moving towards adopting a binding conservation and management measure on forced labor. So the regional fisheries management organizations have been a bit slow to the table, but at least they're starting to get there. So that's something. And the interesting point about the new technology, of course, is the Global Fish Watch and some of the other tracking mechanisms that are being used by non-state actors, coming back to that role again as a way of gathering information. Sorry, there weren't. Sophia, any comments? All right, let me open the discussion to the floor. If we have assistance with microphones, thank you. One over here.
Thank you very much, and I'm very sorry, but I have a train to catch. Well, with regard to the last part, I was particularly intrigued because even though I am one of the least technological people I know, I was wondering whether beyond drones and all these sort of things, artificial intelligence made proof of any utility, putting data together so we can at least virtually elaborate mathematical models or whatever they are to identify the most critical parts and act there. First point, so basically satellites have the issues of clouds. Drones do not have this problem. Perhaps we could borrow the technology used for the Zircon missile or whatever they are, which are able to fly all around the world continuously without having to land anywhere, but I don't know. We should ask the Kremlin. So yes, we have troubles with the space and its dynamics. As far as I know, our frigate, which is currently here it comes again, is able to but if the oceans are 187, then we would need about 370 frigates, and I don't think that even combining all the fleets around the world, we will ever have 370 frigates. But that's beyond the point. So first point. Second point.
Sorry, can we just maybe take one point? Because we do need to get to some other questions.
The problem is criminal prosecution, because even though not every case is expensive as Alayash, which is the billion-dollar case, as it has been called, it is terribly expensive, and no state is willing to engage with the bureaucracy, the finding evidence, all the troubles that come from arresting and prosecuting and whatnot, and also repairing the victims, paying reparations and whatnot. So is there any interest? Will there be any interest? There are major concerns in securing the oceans. Thank you.
All right, thank you. Perhaps if we take a couple more questions. Marco, if we... Anybody else coming up?
Steve, so just that we're clear on terminology, so when people talk about enforcement of human rights at sea, I think we need to be clear about two different situations. So one is when the state commits human rights violations, and the other, the one that I think you all have really focused on, is when state is failing to stop private human rights violations. And the first is easier, we all agree, right? But my question is for Sophia. So Sophia, you said that there are some issues of, I'm going to slightly reinterpret sort of what you were saying, of normative conflict between preventative duties under human rights law and provisions of UNCLOS which may inhibit states from, say, boarding certain vessels. And you said, you know, there's really no equivalent of that on land. But there actually are some equivalents of that on land. So, for example, think of situations where there's a foreign military presence, a UK military presence in Afghanistan, and the UK and Afghanistan consented to that under certain conditions. So, for example, Afghanistan says, you have to give us any detainees we ask for. Yeah? But then the UK or Canada might be in a position of giving to Afghanistan people whom they know are going to be tortured, right? Or you might have situations of people who are, you know, whose human rights are being violated on diplomatic premises. And you might have conflicts between the law of immunities on the one hand and human rights on the other hand. We actually had a situation like that in the UK. There was a guy who climbed the Bahraini embassy in London, and the staff in the Bahraini embassy were trying to push him off to kill him. And the British police barged into the embassy to rescue the guy. Yeah? So maybe the solution to your problem is that in some cases you want to have new exceptions, which can be developed through customary law. In some situations you can rely on some circumstances, including wrongfulness, such as distress. In others, the state affected, the flag state, might not protest, and you can say they actually consented. Yeah? Is Panama going to consent to searching a ship full of modern slaves? In other situations, you might liberally interpret certain provisions that mention the slave trade to include modern slavery. So it doesn't necessarily need to be that difficult, if you see what I mean. But it's perfectly possible that some duties might conflict. It's not the only such case. Oh, Rich.
Yeah, just to add on to Marco's point there, I think there was some interesting literature around this idea of exceptional illegalities, which Michael Byers did, regarding the kind of proliferation security initiative. So the sense there was that states in certain circumstances will be prepared to breach existing norms, for example, the exclusivity of flag state jurisdiction, where it felt that that was justified. And his point was that, well, yes, it's illegal, but actually you just see where that goes. And I guess the point being then, how do states react to that? And what it does is it creates the potential to challenge and to reconceive some of these kind of entrenched norms of international law. Because I think, you know, for example, we have exceptions to exclusive flag state jurisdiction for slavery and illegal broadcasting. I mean, God's sake, illegal broadcasting is so important these days, you know. But it's creating these opportunities for normative developments, I think, which is kind of critical. Of course, the only caveat there is that if you start to erode it for that, there is the risk of an abuse of rights where it could be challenged and countered for other less legitimate reasons. So then the question is, how do you ensure the good faith application of that illegal activity? Oh gosh, yeah, again, circles. So.
Thank you. Christina Sieg. I'm a maritime lawyer first and a law of the sea person second. But this ties into something that is actually coming and going through the day with Haynes and Gombe and Sek as well as Lucci. We cannot rely on flag states to patrol the oceans, and we never have. Or it's a long time since anybody claimed that we did, if I can put that elephant in the room. And instead, we have seen a lot of privatized, basically most flags these days are privatized flags. So this has been filtered, these obligations to safety at sea, etc., have been filtered down through the trade and are now de facto privatized. So there is that issue that has not really been addressed that much in the room. And I think if we think that we have to rely on flag state jurisdiction here to enforce, for example, human rights at sea, we're never going to make it. We have seen port state control with safety issues, etc., expand and expand, in my view, way beyond what was foreseen in UNCLOS and the old Geneva Conventions. I see we're going that way with coastal states. We should see EU doing that. EU has been doing that a lot. So I think there is something there. So when we look at this going forward, I think, sorry, we have to have the, I'm swearing in church, full of international public lawyers now. I think we have to look at the private entities here. And also, Haynes, instead of getting the flag states to support your idea, get the big ship owners organizations to buy in on it. Because they will push for that. They push for the Hong Kong Convention. And they want to push for that because they want first mover approach. They want first mover market advantage. It ain't pretty, but it's got teeth. So, yeah, sorry for swearing in church, but there is a big potential enforcer of this. It is just not necessarily the states. So I think we need to address that. Thank you.
Great, thank you very much. It is a great point to bring up the power of the ship owners and the shipping companies and also the manning agents as well when we're thinking about seafarers most particularly. They're very much at the mercy of those companies that are acting under the shell of the flag states. And I think goes to Sarah's earlier presentation where the thinking about the human rights due diligence and thinking more closely about the supply chain is going to be something to consider. But let me not hog the microphone. Sophia, did you want to start with the responses?
Thank you very much for the questions. Well, in terms of the examples that you gave, Marcus, so for example, foreign military bases, it's not quite the same with the right of innocent passage, because for the right of innocent passage, you don't need the consent of the coastal state. You have this right, you can exercise it. You need to comply with certain coastal state regulations, of course, but you don't need the consent of the state. And actually, the convention is very clear that no restrictions should be implemented whatsoever when it comes to the right of innocent passage. So I don't think that it is quite the same thing. There are some analogies, but it's not the same, and that's why I think that it's very unique. Now, in terms of the exceptions that you mentioned, this is already done in practice. So, for example, when it comes to maritime security, we've seen a series of conventions where states say, okay, we want to fight against illegal activities against vessels, the Suez Convention, or we want to fight against the smuggling of migrants, so you have the Migrant Smuggling Protocol. And there are a series of conventions that try to introduce these exceptions. So for the purposes of dealing with these illegal activities, we allow boarding. But the boarding is subject to the consent of the flag state. So there we see that while states want to move forward and find solutions to the problems, they always come back to this very fundamental principle of the law of the sea. We could do the same for human rights. I mean, we discussed this in a conference we had a couple of years ago at Wilton Park, and there were discussions about having bilateral agreements or, an international agreement where states agree to allow boarding for the purposes of human rights inspections. Again, if this happens, it will have to give due consideration to flag state jurisdiction. It will not happen just like this. I mean, you can waive consent somehow, but again, it will have to have some certain safeguards, because then there is a risk that Richard mentioned. You introduce so many exceptions, and then the law of the sea will go out of the window, and I don't think that states want that. And just a very quick reflection on what Christine said, I fully agree. I mean, that private actors can play a very important role, especially in the fishing and shipping industry. I mean, in the shipping industry, it's more about private actors. It's about the owner of the vessel, the manning agency, security boards who are on board. They're private actors, they're not state actors. And there's a lot of potential there, But this can be developed, along with what states have to do. It should not be one or the other. They can work, we can work towards that direction as well. Thank you.
In view of the time, let me just run across the entire panel to make comments on this. I'll come to you, Stephen, at the end, but maybe if I just work my way across, if any of the panelists want to address any of the questions we heard.
Just two comments. The first on Christine. Yes, the importance of the role of private actors when dealing with the question of public interest was exactly what I was dealing with when I say this, when I explain you this case law concerning the private shipmaster that is really a state agent when acting. In this case was search and rescue, but the same patterns can be applied to every action of the shipmaster in the public interest. So that was exactly my idea. And I have just a little comment on the distinction between positive and negative obligation in Marco's view. My point is that I do think in these cases is extremely difficult to distinguish between positive and negative obligation. If I take the examples I gave you, we have a private ship's master who is acting as a state actor, so we have the jurisdiction and the responsibility of the state under human rights treaties, but at the same time, when that search and rescue activity were carried out, the Italian state didn't even know that it was happening. And so we have the state jurisdiction on, and I would say a violation of a negative obligation, because being a state actor, the shipmaster bring these people in Libya, but then we have a number of positive obligations by the state, meaning the obligation to carry out prosecution of on this person, and even the obligation, well, the choice from the Italian state to give these people humanitarian visa to come back to Italy. So it's positive and negative obligation are so strictly linked that I do think it's quite difficult to apply this straight distinction between positive and negative when dealing with the jurisdiction. Just.
Well, it doesn't quite fit with what the last speaker just said, but I think it's important to bear in mind what different fora can perhaps do on these issues. When the COVID issue and the seafarers and were adversely affected by the COVID situation and weren't allowed into port, etc., stayed at sea, the issue went from IMO to the UN General Assembly and ended up in a UN General Assembly resolution. A lot of things are possible. So, and the IMO has been dealing, at least when it comes to merchant ships, it has been dealing with issues of abandonment, et cetera, et cetera. They also have the certification, the training. They have a mandatory audit scheme, which I think could include also human rights considerations. It could be expanded. So much for the merchant vessels. Now, when we're talking about the fishing industry, well, we have FAO, we have the Regional Fisheries Management Organizations and arrangements, and I would even say we have a new agreement, the BBN, I'm not going to repeat the entire title again, I'll just say the BBNJ agreement, that also perhaps provides an opportunity to raise some of these issues, because we are dealing with conservation and sustainable use of marine biological diversity. So the people that are actually out there, and if It doesn't, while we have the not undermining clause, it also provides for room where the various organizations that are competent in the area, or where there may not be a competent organization, to raise these issues. So I would even say that there's room perhaps of scope there. So, but the important thing is to bring these matters to the level of these organizations and these processes. That is the trick. And you need a champion state to do that. Thank you.
Just a comment on what Christine said. I mean, I could not agree more in the sense that I think that the role in this case of operators and license holders is really key. And that's one of the element or the component that need to be part of the narrative. Under the EU legislation, for instance, we have specific provisions on that. We have a point system, you know, where we assign certain points for infringement, which can lead to the permanent suspension of the fishing license. So we tackle not only the material executor, let's say, of the offense, but also what's behind. And then, of course, these need to be read against the overall infrastructures. I mean, so we need the specific rules on trade, for instance. We need specific rules for operators. And for that, I think the role of NGOs is really key, in the sense that you mentioned it before, you know, the examples of how we can change also the practice. I think for traceability, this was really one of the main components, you know, was the consumer who asked for a better traceability of the fishery products. And then I think in this case, then the NGOs have a very important role to play in this as well, you know, to try to push through advocacy for changing some of the aspects concerning the practice as well.
Thanks very much. I've got 1 or 2 points, but I see that the gentleman who asked the question about drones and things has left the room. But let me just say straight away that I'm a great fan of technology that produces new solutions to problems. But at the same time, it doesn't produce the entire solution. And drones, whilst they're very capable, and certainly a great deal more of them could be used for monitoring what's going on at sea in terms of location of boats and so on. Actually, you need people on board boats to find out what's going on in human rights senses. And that can't be achieved by drones. It's achieved by enforcement units being at sea in the relevant sea zones. And that's a big problem because we're talking here about capacity. There isn't massive capacity globally. And getting states to provide it, and I think in most cases it will be states, although there are private companies now providing security resources. It's a problem. It's a really big problem, and clearly, as we move forward in this century with global ocean governance, we need an effective way of monitoring things and taking things forward. I got 1 or 2 other the shipping companies issue. I don't disagree with you, but at the same time, shipping companies flag out to open registries for reasons to do with bottom line and margin. And there is significant evidence that we've come across that shipping companies are not, generally speaking, very sympathetic to the idea of human rights at sea, and nor in particular are the shipping unions. And the shipping unions and the shipping companies do have a close relationship, obviously. Now, I think that we can overstress that problem. The Maritime Labour Convention, of course, is a very important convention which has a serious overlap with human rights law. Of course it does. And so one of my suggestions to my human rights at sea colleagues is that we get closer together with the shipping unions to see if we can't work out some sort of arrangement that would be mutually convenient, which would serve both of our purposes. But shipping companies will go where they need to go, and we've had plenty of evidence that crime, including human rights violations, take place, for example, on cruise ships, and the cruise ship companies have a vested interest in not reporting that to authorities as a result, and so a lot of that crime goes undetected by the official authorities. So yes, I'm always very keen indeed to see private enterprises getting involved, but then again, they're not a panacea, and so states really need to be engaged, and that's where my principal focus is going to be going in terms of getting human rights at sea's Geneva Declaration accepted. There's another move beyond that. I mean, other ways, we decided not to go for a convention because, of course, states need to be around the table to negotiate that. But I could see a situation in the future where human rights issues are somehow put under some sort of conventional law, a sort of variation on a theme of the Sewer Convention, so that we can actually achieve a degree of agreement over flag state approval for boardings and so on and so forth. But we're a long way short of that at the moment. There's a lot to do, basically, is my basic message, and we've got to start moving it forward as progressively and seriously think about this. And tomorrow's meeting, Irini, is an absolutely vital part of this process. Thank you.
Great, thank you. Unfortunately, I will have to draw the discussion to a close at this particular point, but if you could please join me in thanking all of our speakers. And I now hand the microphone to Irini for our closing remarks.
Thank you very much. I won't even try to resume all the discussions, all the points made, all the provocations brought. I will just say that as probably is evident at the end of this long day, there is a lot to discuss about jurisdiction at sea and protection of human rights. And I think that there is a fundamental question, which is when we discuss protection of human rights at sea, should we use jurisdiction only under human rights law, or should we only refer to international human rights law? Or should we also look for jurisdiction elsewhere, in the law of the sea, in domestic criminal law, in other fields of international law, in European Union law? So how can we use all these different concepts? Should we subsum them all under jurisdiction under human rights treaties? But this seems very difficult. Or should we somehow admit that they are separate, but somehow try to find ways of interacting and ensuring a better protection of human rights at sea? Now, I am about to close the conference, but I cannot do so without really thanking all those who helped this event. Any conference is a collaborative effort. No person alone can do anything. And I have been blessed in having had the help and collaboration of excellent people. So first of all, I would like to thank, of course, the funding bodies, again, the European Union, the Ministry of University and Research. I would like to thank all of the speakers and chairs who have taken the time, also sometimes in adverse conditions, to fly to Milan, to travel to Milan, to provide us with their valuable knowledge and questions and provocations. All of you who have been here today, that have survived this very long day, my colleagues at the University of Milano Bicocca who have very kindly participated, colleagues from other universities of Milan and other universities across Italy. And let me end by thanking in particular few persons. I would like to thank Giulia Losi and Bernardo Mageste for helping with this conference. I would like to thank Valentina and Shaima, who have worked throughout the day and past days in ensuring that everything runs smoothly. And I would like to finish by thanking the one person that has really provided so much help in the last months and weeks, working when I could not bring anything forth. At a certain point, just solving problems without even mentioning them to me. And that's Tommaso. So thank you to all for this event. And A final thing, we have recorded the conference, so if you missed a part, it will be available in the next few days, and you can hear again and again everything.